May I have the appearances, please?
Abby Nikolai, Randy Sitzberger, and JJ Crawford for the state.
Donna Kukler and Pablo Galaviz appear with Ms. Kurczewski. Good morning.
Right, good morning. I know all the jurors are here. Anything I need to address before we bring them in from the state?
No.
From the defense?
No, thank you.
All right, then, Ms. Eisenhardt, if you want to come back up to the witness stand, just so you know, it's my practice day 2 to have you sworn in again, but I'll do that in front of the jury.
All rise for the jury.
Excellent. Still those ones in the back. Thank you, everyone. You may be, Madam Clerk will swear you in for day 2.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Have a seat. And good morning, ladies and gentlemen of the jury.
Morning.
And I just would ask for the record again if you would state your first and last name.
Yes, my name is Linda Eisenhardt.
Thank you. Go ahead, Attorney Kukler, when you're ready.
Good morning. I'm waiting for the screens to pop up here so we can start today. Good morning, Ms.
Good morning.
Eisenhardt. We'll start where we left off yesterday, if that's okay.
Okay.
Now, wait, I'm just going to wait for the jury screens to come on.
Okay.
Okay, so we left off here, slide 16 yesterday, and as I recall, just to reorientate ourselves, you were comparing a check of Lynn Hernan's to her known handwriting and to Jesse's known handwriting.
Yes, that's correct.
And we left off with, after you compared it to Jesse's, there's support that Jessy didn't write that check.
Correct. My conclusion was a limited support for different sources for Jessy for the handwritten portion of that check.
Okay, so should we move on to the next slide and start with your next points you want to make?
Yes, please.
Okay, great. So here is the next slide, which we're starting with slide 17 this morning. Can you explain to the jury what you're trying to show here?
Yes, so this slide is transitioning to a third writer that I was asked to compare. That is Jennifer Flower. So you'll see her known writing on the bottom portion of the slide. And also to draw your attention to this being a third writer, I'm using a green color. And so this is the same portion of the question check at the top. And again, I'll walk you through some of the observations that I made during that handwriting comparison. So starting with the J, the capital J in the question document in the word Jessy, Again, that same formation I had highlighted for the other writers, examining the known writing provided to me. That was Jennifer Flowers' known writing. I had a couple of examples of her cursive J formations, and those were inconsistent with the questioned writing. Next slide, please.
Oops, there we go.
Moving on in the question document to the Y in Jessy. Again, this formation we talked about a little bit yesterday. That characteristic was observed in the question writing to be somewhat different than you would expect in the way that you're taught to write. And so I evaluated the known writing I had from Jennifer Flower, and I included a couple examples of the cursive Y in her known writing on the bottom, notated by those green arrows with the circles, and those were inconsistent with the questioned writing. Slide, please.
Yes.
In the question writing, in the last name Kurczewski, the capital R formation here. So this was a characteristic that I noted, the capital R in the middle of the name, and the formation of that in particular, I was able to find an R formation in Jennifer's handwriting that I did think was formed in a similar way. So this was a similarity between the question and Jennifer's known writing. And the lowercase k that we talked about a little bit yesterday as well in the questioned writing, this is the K.
Black Friday starts now at Jerry Center Kia. New Kia Sportage, $289 a month. At the #1 Kia store in the Salt Lake region, Jerry Center Kia, Salt Lake.
Now moving on to the second line of the question writing, the cursive T in the word to. I didn't have a lot of examples of a capital cursive T of Jennifer. This was one of the few that I had on the bottom that you'll see the arrow pointing to. So again, that characteristic was inconsistent between the questioned writing and Jennifer's known writing as well. And so,
Conclusion?
yes, I did. Those characteristics that I demonstrated, as well as numerous others, led me to the conclusion of support for different sources for Jennifer Flower for that item 49 handwritten check.
So meaning that there's support that someone else other than Jennifer Flower wrote that check.
My conclusion is specific to Jennifer, just saying there's support for different sources. She may not have prepared the handwriting on that check.
Okay. Now what's this? This isn't. Is this the same check?
This is the same check. Now I added the red box around the signature. I examined the body of the check separate from the signature. Handwriting comparison I did with Lynn Hernan's handwriting as well as Jessy Kurczewski's handwriting for the signature. I just wanted to note I did not have samples of Jennifer Flower writing a signature of Lynn Hernan, so I was not able to perform a comparison with her for the signature in particular.
So you compared it to Jessy.
To Jessy's and to Lynn's
And to Lynn.
handwriting as well.
So first we looked at who
Served. Starting out with the capital letter L in the questioned writing, that formation CL, I was able to find in examples of Lynn Hernan's known writing, which is depicted on the bottom portion of the slide. And so those L's were considered similar in my analysis.
That's why on those arrows, there's no circle at the end,
That's correct.
because when they see
Shape of what we call the bowl. So as you might imagine in a cursive Y, the top portion of that looks like a U normally. This question signature formation, and then the area where it descends below the baseline is elongated with a loop. So I looked for that characteristic in Lynn Hernan's known writing in the samples that I had as depicted below on the slide. And as the red arrow indicates on the bottom right-hand corner, I was able to find that same formation of the letter Y in Lynn's known writing. So those were similar. Moving on to the last name, H, there's some interesting detail in the way that this is formed. The H is a little bit shorter than the capital L. The slant of the vertical lines, and then of course the connection from the right vertical line to the curve to
well,
So this is a marking that I use to indicate a baseline characteristic. The A in the questioned writing is quite a bit higher compared to the bottom of the N. And this is something that individuals do somewhat subconsciously. They're not really thinking about it. And so I wanted to see if I could find that same characteristic in Lynn's known writing. And I was able to find that again in the signature depicted on the bottom right-hand corner, you'll see with the similarity arrow. So that baseline characteristic was similar between the question writing and Lynn's known writing.
so after looking at all those letters and comparing them, did you reach a conclusion?
I did.
And what's that?
So my opinion, considering those characteristics as well as others, was that Lynn may have prepared that signature, and it's a support for common source opinion. I do have to note one limitation in particular, because as I stated, these checks are low resolution and they're not original. I was not able to evaluate the possibility of simulation or tracing. And that is something that if I had the original, I would have been able to do. So that's an important thing to note in this conclusion.
And like we talked about yesterday, I think you said that if you had had more known writing samples in general of Lynn, it would have been more helpful.
It would have, but in this particular instance with the signature, I think the most important thing at the three-dimensional aspects of the signature.
And you were given photocopies, is that right?
Yes, all the checks were non-original documents. They were images, I think, that were printed out.
Okay. And those came from your FBI field office, is that right?
That's correct.
All right.
Yes.
Now, here's the next slide, which we're now on slide 30. What are you doing here?
So in this slide, I begin the comparison with that same signature on a question check, now with the known writing provided to me by, or known to have been attributed to Jessy Kurczewski. So on this slide, beginning again with that capital L formation in the question signature, looking for that formation as well as the slant. And in the known writing that I had from Jessy, I was not able to find the same formation or the Jessy's known writing.
And that's why it's got the little circle at the top of the arrow.
Yes, that's correct.
Okay. Here's the next slide.
That same Y that I pointed out in the questioned writing, again, I was looking for that formation in Jessy's known writing. I depicted a few examples of her writing, of Jessy writing Lynn Hernan's signature, and I was not able to find that same formation of the Y in the question writing, and so those were inconsistent.
Next slide.
The capital H in the question writing, again, this formation with the details that I had previously described, I was looking for that same formation in Jessy Kurczewski's known writing, and I was not able to find that same formation. I put an arrow on the signature below that I think came the closest, but that was still inconsistent in the execution and the detail of that H.
So again, that arrow has a circle.
Yes.
Here's the next. So here's, now you're looking at, you've got the stairs again.
Yes, and I apologize. There's a arrow that was held over from the previous slide. So if you could just ignore that for this slide, please. I did want to draw your attention again to that baseline characteristic in the question document where the N in Hernan is much lower and the A is much higher in the question document. And so I examined the known writing to see if I could find an example of that baseline characteristic in Jessy's known writing. I was not able to find it, and I pointed out an area here just as a demonstration where it was inconsistent.
Did you reach a conclusion then as to the comparison between that check signature and Jessy Kurczewski's known writing?
Yes, I did.
And your conclusion is?
So my conclusion was a limited support for different sources, and that was that Jessy may not have prepared that question signature.
Okay. Is that the end of the PowerPoint?
I believe so, yes.
Yeah, so we'll take this down, Madam Clerk. Thank you. So you also did prepare a report in the case, and we introduced that yesterday, right?
Yes.
And you made conclusions about, did you make conclusions about all of the checks that were submitted to you?
Yes, I did.
And do you, on the checks that were submitted to you, I think we established yesterday, there were items 47 through 64. Does that sound right?
Would it be okay if I refer to my notes or see a copy of the report just
Yes,
to?
and actually, I've got the
Sure.
number wrong. You can, but it's 47 through 83. Oh, could I show that to you?
Go ahead. Yes, the checks were items 47 through 83. That's correct.
Okay.
Thank you.
So over 30 checks. By my math anyway, over 30 checks.
Yes.
And when it came to the checks, your conclusions were either that there was support for different sources as it relates to Jessy Kurczewski, or you had some inconclusives.
Objection, Your Honor, leading.
Overruled. She may answer.
I'm sorry, could
Is
you
that
repeat
fair?
the question?
I'm trying to get you to get us a conclusion on the checks. As we deal with the checks, would you agree that you have observed, your conclusion on the checks was that they were likely not prepared by Jessy, or you may have been inconclusive on a few?
Yes, that's fair to say.
And as it relates to Lynn Hernan and the checks, do you have a general opinion that you can offer on that comparison?
Yes, with the majority of the checks, with the handwritten portion, not including the signature, my conclusion was support for common source. There was at least one check that I was inconclusive on. There were some issues with the check. It looks like perhaps the image had been distorted. And with the signatures, with respect to Lynn, there were 2 of the 30 plus that gave us support for common source on, and the remaining were inconclusive with regard to whether Lynn wrote the signatures on the checks.
And then did you compare a handwritten letter from Lynn to Jessy? Was that one of the items that you compared? If you recall?
I'm sorry, I don't recall specifically. There were a lot of documents that I examined.
Well, when it came to let's go through them. We have item 20, which is a page that started with, and maybe it would be easier if I just pull it up on the computer.
Yes,
so we
thank
can
you.
take a
That would be
look at it.
helpful.
Let me do that. Okay, could I have a screen share on, please, for the witness?
Go ahead.
Is this one of the documents that you review? Oh, it's not up yet, okay.
Your computer's up, but
Cord is plugged in. Oh, look at that.
might have to duplicate again. That was the issue yesterday.
Let me just see here. Maybe I'll just duplicate. That should help. Here we go. It should be over there now.
It is.
Yes,
Let me
thank you.
close the side. This is what I see you have marked as, this was Exhibit 522 and is item 20, I believe. Do you agree?
Yes.
And this particular, this is one document that you reviewed and analyzed.
Yes, that's correct.
Your Honor, move for admission of item or Exhibit 522, please.
No objection.
Exhibit 522 is received. And
Ask to publish.
and permission to publish granted.
Okay, we're looking at Exhibit 522. Do you recall what your conclusion was as to whether Lynn Hernan, using your scale may have, is it your conclusion that Lynn Hernan did prepare this or did not prepare this particular exhibit?
Your Honor, would it be okay if I refer to a copy of my report just to be accurate?
I don't have an issue. Any objection from the state?
No.
Okay, your report has been received already, I believe, as Exhibit 501.
Copy with you or do you need?
I do have a copy of it.
Why don't we utilize the copy in our box? I know that has, and then you can confirm that it's the same thing, but that's what's been received.
Thank you.
Find it.
Otherwise, I haven't written on mine. And we can swap out. I haven't used mine. If you want to use mine, and then I'll take the one in the box later. I've not made any notes on it yet. All right, so the witness is being handed Exhibit 501.
Thank you.
You're welcome.
Okay, now that we have the exhibit before you, what did you conclude about this particular document as to whether Lynn prepared it?
So my conclusion with regard to this item for Lynn's comparison, or excuse me, the comparison with Lynn was a support for common source for item 20, including the Lynn Hernan signature and the handwritten text, but excluding the 14 January 2016 entry written in blue ink.
So the date.
Yes, the bottom portion of the exhibit that's depicted here. There's actually 14 January 2016, but the copy that I had was in color and the bottom entry was written in blue ink. So I specified that portion.
And I'll show you what is item 21 in your list of items and is marked. Could we bring this down while I bring up another exhibit, which will be Exhibit 523, item 21. There, it's up. Is this, I'm going to show you an exhibit sticker 523. Do you see that?
Yes, I do.
And this is item 21 in your list of items reviewed. Can you just take a look and see if this is that item? I'm scrolling down so you can see the 6 pages. There we go.
Yes, I am familiar with this item.
And you evaluated this item.
I did, yes.
Your Honor, move for admission of Exhibit 523.
No objection.
Exhibit 523 is received. Permission to publish granted.
Thank you.
What was it? Okay.
The jury's seen this document before, but let's wait for a minute while it comes up on their screens. All right, that's up on the screen. So you compare this document to known handwriting of Lynn Hernan. Is that right?
Yes, that's correct.
And your conclusion as it relates to this document, as it relates to Lynn Hernan, is what?
For item 21, my opinion was a support for common source.
We are ready to get started on this boutique hotel here in downtown Waco.
53,000 square feet.
It's going to be a big project.
Ladies and gentlemen, without further ado.
Jury signature, so that was not included in my
And
exam.
we've already heard from the notary who has agreed that she notarized this particular document and that was her signature. So would be not expected to match Lynn Hernan's, right?
I did not examine it.
All right. This document can come down. Thank you, Madam Clerk. Now, just in general, is a person's writing affected by things like, I don't know, like whether they're under the influence of drugs or alcohol, for example?
Yes, there are a number of factors that can influence people's handwriting. Drugs and alcohol, as you mentioned, the environment in which they're writing, maybe in a car, on the surface that they're writing, emotion, as well as purposeful intent in changing their handwriting. So there are a number of internal and external factors that can affect people's handwriting, yes.
So does somebody's handwriting, is it different if you're sitting upright, for example, in a chair versus, just as an example, laying back in a hospital bed, for example, and writing? Make your handwriting vary?
Yes, there could be effects on the handwriting. I would certainly expect that there would be probably less control of your hand and your arm as you're laying back, but there would be limits to the effects that it would have on your handwriting.
How does a person's mental state affect their handwriting? You mentioned mental state. I'm not sure.
I don't recall if I did, but that could affect their handwriting, yes.
Okay, I'd like to share the screen with the witness.
Okay, go ahead.
Oh, no, never mind. I don't want to bring this one up quite yet, actually. Just looking for a different one. Did you look at the cards that were submitted that are happy birthday cards? And they say things at the top like Karini or happy birthday, Karine, or Karini, that spelled out different ways. Were these the items, item 9, these cards, were these what you consider to be known writing samples of Lynn Hernan?
Yes, that's right.
And item 9, which seems to consist of, I'll show item 9 on the screen. Can you see this on the screen?
Yes, I can.
And this is Exhibit 511. Do you see that sticker?
I do.
And I just want to go down. It looks like 4 pages to me. I'll scroll just to see if these are the 4 pages. Is that right?
Yes.
So that's what you have called item 9. But we're introducing as Exhibit 511. Did you use these documents as your known writing sample for Lynn Hernan?
Yes, these were part of the known writing sample I had for Lynn.
So move for admission of 511, Your Honor.
No objection.
511 is received. We did see this exhibit previously.
I agree, but
I just want to let the jury know what number that was. I believe it's 49, State's Exhibit 49 will be the same as 511.
Thank you. And we have it separate, it is a separate exhibit because these were documents that you received and want to clarify what you received. Okay. So these cards were given to you and told that these are known writing samples of Lynn Hernan.
That's correct.
Now, would it have been helpful if you could have had more cards, more letters from Lynn?
Yes, it would have been.
That can come down. I don't need to be showing anybody anything on the screen right now. Thank you. I wanted to show you, I actually do want to show you another exhibit. I would like to show you item 64. I'm just going to scroll through these checks. Here we go. Can you see item 64 on your screen, Ms. Eisenhart?
Yes, I can.
This is one of the items that you evaluated, right?
Yes, it is.
Asked to have this as an exhibit number, Your Honor. It's 524. Do you, Ms. Eisenhart, see the exhibit 524?
I do.
Move for admission of 524.
No objection.
All right, Exhibit 524 is received and permission to publish granted if needed. Do you know what item number?
64, and I'd like to publish.
Go ahead.
Okay, it's up. Item 64, what was your conclusion on this check as to whether or not Lynn wrote this check?
The handwriting in the who it was to, pay to the order of, so not including the signature. My conclusion was a support for common source for Lynn.
And I just see on this check that she wrote Jesse's name incorrectly. And this is for a walker at Walgreens. It looks like in the subject line, true?
Yes.
And you evaluated all of these checks, 61, 62, 63?
Yes, I did.
City of Pewaukee, for example, Jessy, Kurczewski. Is that right?
Yes.
And checks, for example, in Phase, Jessy, City of Pewaukee Precision Service Consultants. You were given all of these checks to evaluate, is that true?
Yes.
Anthony Poza check for 200, electric, Phase Electric, more City of Pewaukee, is that right?
Yes.
And so all of the checks here in this case, these can come down, you evaluated.
Yes, I did.
And one of the items that came from your lab is called evidence check-in notes. What is that all about?
That's a document that we create in the laboratory when we first open up the packaging and start to inventory the items that are submitted to us for examination. We, as we've discussed, apply an item number, and the check-in notes have additional descriptions of those items so that we can correctly identify them.
And that has been marked as Exhibit 502. Let me bring that up for you. Do you see the sticker of 502?
I do.
Seems to be 10 pages. Should I page down really quick so you can make sure it's yours?
Yes, please.
All right. Is that your evidence, FBI laboratory evidence check-in notes?
Yes.
And so this will list everything that you received in this case.
That's correct.
Move for admission of 502, Your Honor.
No objection.
No need to publish.
Exhibit 502 is received.
And you said, I think, that after you completed your review of this case, that somebody else at the FBI also reviewed the case.
That's right.
They reviewed it independently of you, or do they just look at over what you did?
So in this scenario with this case, I gave all of my paperwork, whether that be digital or physical, notes, including what the request was, my notations, and my report to another examiner. So they were aware of what my findings were as they were doing that verification.
And then they verified. Well, did they verify that? Did they agree with your conclusions?
Yes, they did.
If they didn't agree with your conclusions, what would happen?
We would have some conversation about why, usually a discussion to detail if they thought I had overlooked something, or if I had perhaps weighed something in a way that they were in disagreement with. And so that process is not unusual. We go through that on every case. And if there are disagreements in details, or if I've left things out, then I'll go back into my notes and make either additions or changes, being sure that any of those are transparent. So for example, any changes that I make would be a strike through one single line so that you could read what was originally there and just be clear on what I was clarifying, changing, or adding as well.
Would it be fair to say that if more known handwriting was discovered during the case, that could be collected and sent to you and a request made to do a further evaluation?
Yes, that can be done, and often is.
It is often done.
Mm-hmm. Yes.
But it didn't happen here. Is that true?
No, it did not.
Okay. Thank you very much.
Right, cross.
If we could pull up Defense Exhibit 628, please, or 619, apologize. And going to slide 10.
You want it published right away?
No, just for the witness. Thank you.
All right.
Ms. Eisenhart, there's a note on the very bottom of this slide that talks about the degree of support for same source may range from limited to strong. Do you see that?
I do.
Okay, so there's later opinions given in your in this PowerPoint on page 16, for example, if we could flip to that, where it talks about limited support for different sources. So that's on one end of the spectrum compared to strong, correct?
Correct.
So in what sense is limited mean in this context? So does that mean that it's weaker support for different sources, or how does that work?
Yes, it does in fact mean, in this case, if I apply a limited for this opinion, which was support for different sources, it is weaker in that qualitative range compared to no qualifier or a strong qualifier.
So in this case, on Exhibit 16, if you were to put strong support for different sources, is that actually closer to source exclusion?
Yes.
I want to move on to page 29 of that same exhibit. You remember that?
I do.
So in terms of checks, is it common for checks to have a checkbook, right?
Yes.
And under that checkbook, there's usually a second page of that check where it kind of gives the person who's writing that check some verification that they wrote that check for future reference, correct?
Object to speculation.
Sustained as the foundation.
Okay. Are you aware that when someone's writing a check in most checkbooks, there's actually essentially two checks that are associated with the same check?
Are you referring to a carbon copy, for example?
You summarized that much better than I did, so thank you. Yes, I'm referring to the carbon copy. Are you aware of that process?
I've seen those before, yes.
Okay. So in theory, could somebody simulate or trace based off that carbon copy?
Yes, the carbon copy would have examples of the signatures prior if they had access to them, and that could be a model used for tracing.
Okay. So if someone had access to somebody's checkbook, they could look back at that carbon copy and look at that and potentially trace it, correct?
That would be one way they could trace it, yes.
And in this case, you were not able to determine if there was any tracing or simulation done because of the nature of the actual question items, correct?
That's correct. Since they were not original, I was not able to evaluate that possibility.
Okay. If we could go to page 30 of that same exhibit, please. Now, if we could publish this actually to the jury, please. Thank you. On the top of page 30, we see item 49 question signature, correct?
Correct.
And then on the bottom left, we see Jessy Kurczewski known writing, correct?
That's right.
And that's actually from item 26.
Yes.
Is item 26 a document that contains multiple signatures of Jessy Kurczewski writing out Lynn Hernan's signature?
Yep. Yes, that's correct.
So if somebody was around somebody for multiple years and had access to their checkbook and was able to look at their previous signatures, would it be possible to change your signature when asked to provide a known handwriting here?
See, object to speculation.
Overruled. He's asking her an opinion based upon her training and experience. She may answer.
Yes. So one of the things that we do note as a limitation with what we call dictated writing, that's the term that I use for describing writing that's collected as part of the investigation. Usually it's witnessed. That's what item 26 included, was signatures from Jessy that were witnessed for this investigation. There is a possibility that one could purposefully change their handwriting style. And that is actually why it's really helpful for us to have the other type of known writing that I mentioned yesterday, normal course of business writing. So letters, greeting cards, checks, job applications, so that we can evaluate if the known writing that was witnessed and collected for the investigation is or is not consistent with that person's normal writing. So that is a concern, and having both of those types of known writing helps me to assess the possibility that they might be altering their handwriting.
So is it fair to say then if someone's purposely changing the signature or handwriting, it's very hard to actually compare the two, correct?
I could compare it if I only had signatures or writing that was collected as witnessed as part of the investigation. That would be something I would be concerned with, a possible limitation. And I would ask the investigators to provide examples of that person's writing outside of the investigation to get a better sense of whether they're giving their true and natural writing style.
In this case, there's been previous, I believe, video or testimony that Ms. Kurczewski actually admitted to writing out some of these checks that were evaluated. Would that impact your analysis for comparing her written text or signature in this case?
No, it wouldn't. However, additional known writing would be welcome if that was something that the investigators were interested in. I have to make my conclusions based on the evidence in front of me, and verbal information about that doesn't really give me anything to compare.
So looking at your lab report under the Jessy Kurczewski section, it talks about how your conclusion was ultimately there's support for different sources for the handwritten text and signatures from checks 47 to 56 and 58 to 83, correct?
Yes, that's right. And including the numerals and the signatures.
Okay. Would that opinion change given the information I just talked to you about, that she admitted to writing some of these texts?
So my opinion is only based on the comparison that I did. If she admitted to doing that, that's separate evidence from my handwriting comparison.
Would that seem to call into question your conclusion if she admitted to it, but you are having an opinion that there's support for different sources though?
Just an answer.
Overruled.
I'm sorry, could you repeat the question?
Yeah, so if she admitted to writing these checks at times,
Okay.
would that call into question your conclusion of support for different sources for Ms. Kurczewski?
Just to clarify, are you saying that she admitted to writing some of these checks that I examined?
Correct.
Okay.
States the evidence. It's not what the evidence supports at all.
Your Honor, she admitted to writing.
I'll take it as a hypothetical, so which she can answer. She can assume it's for the jury later on to determine if that hypothetical is based in facts established on the record.
So, I mean, it would certainly give me pause, given that I gave a limited support for different sources. As I mentioned, there are some limitations to my examination. Perhaps some additional known writing from Ms. Kurczewski that would demonstrate some of the characteristics I was not able to find in her known writing. Perhaps also having the original question signature could elicit some more information. However, with the evidence that I was given, I do stand by my conclusion that I gave.
Okay, that's fair. I want to walk us through some of the items that you were provided here as well. And I want to start with the same sort of checks. So your conclusion for Lynn Hernan's signature on checks 47, 48, 50 through 66, and 68 through 83 were inconclusive, correct?
Could you repeat those numbers, please?
Absolutely. 47 through 48, 50 through 66, and 68 through 83. All of those question signatures, you came back with the opinion that it was inconclusive for Ms. Herning, correct?
Yes, that's correct.
I want to direct your attention now to, it's actually been marked as Defense Exhibit 503. That's item 1 in this case. If we could just publish that to the witness, please. And I'll just have you scroll through this, please. Thank you. Ms. Eisenhart, do you recognize this document?
I do, yes.
And is this item 1 in the set of documents that you analyzed?
It is.
Your Honor, move Exhibit 503 into evidence, please.
No objection.
Exhibit 501 is received. Permission to publish granted.
It's actually 503, Your Honor.
What did I say? Oh, 503, sorry. I should probably put my
I
glasses
just wanted
back
to make
on.
sure we were on the same page. Thank you.
My defense, it's item 1.
It sure is. In the highlighted portion here, if we could just scroll down briefly, Ms. DeValkenier. The highlighted portion of item 1, was your conclusion that there was support for different sources of Ms. Hernan's handwriting on this?
Yes, for Lynn Hernan, the portion that's highlighted, it was 3 lines there underneath the number 1 before number 2. That specified portion, I gave a support for different sources in comparison to Lynn's known writing.
If we could scroll to page 2, please. And go to the bottom. You see the highlighted portion of this, correct?
Yes,
And the question portion of this page is Ms. Hernan's signature, correct?
correct.
Your conclusion for this was support for different sources, correct?
Yes, that's
So
correct.
your opinion is that there's support for a different source that other than Ms. Herning, correct?
Yes, it was a support for different sources compared to Lynn.
If we could next pull up just for the witness item 2, and I believe it's Exhibit 504. If we could just scroll through that, please.
Okay.
Do you recognize this document?
I do.
And again, this is item 2 in the question documents that you went through.
That's right.
Your Honor, move Exhibit 504 into evidence.
No objection.
Exhibit 504 is received. Permission to publish granted.
If we could put that on for the jury, please. So, Ms. Eisenhart, if we could, Mr. Volkner, actually, if we could just go all the way to the bottom of page 2 again, thank you. You see the highlighted portion of that, correct?
Yes,
Your conclusion was support for different sources for Lynn Hernan as well on this, correct?
yes, that's right.
If we could pull up Exhibit 505, item 3. And then scroll through that document, please. Do you recognize this document?
I do, yes.
Is Exhibit 505, Item 3 in the question documents that you reviewed?
Yes, it is.
Or I move into evidence 505.
No objection.
Exhibit 505 is received, permission to publish granted if requested.
Yes, please. Thank you. If we could scroll down, Mr. Volkner, to page, I believe, 4. And if we could just stay right there. There's no highlighted portion of this section, correct, Ms. Eisenhart?
That's correct.
However, I'm going to direct your attention to the left side of the document where it's the Lynn Hernan under print purchaser name, the address, and then the signature. In reviewing those 3 lines, you came to the conclusion that there was support for different sources for that writing and signature, correct, for Lynn Hernan?
Yes, for Lynn Hernan, for the handwritten text and the Lynn Hernan signature, my opinion was support for different sources compared to Lynn's known writing.
So just to remind the jury, that means that it's your opinion that she may not have written or signed that document, correct?
That's correct. And there are limitations with all of those support for different sources conclusions.
Correct.
But yes, that's right.
If we could scroll to page 5, please. Again, there's no highlighting on page 5, but you evaluated all of the handwritten text and signature in this, correct?
I did, yes.
Again, for Ms. Hernan, for the handwritten text as well as the signature, your conclusion here was there was a support for different sources, correct?
Yes, that's correct.
If we could move to Exhibit 506, please. This is item 4. If we could scroll to page 3, please. And then page 6. Are those 2 portions of item 4 that you would have been analyzed in this case?
Yes, they are.
And this is Exhibit 506. Did you see that?
I did not see that. I'm
You
sorry.
could scroll to page 1 to just show her the exhibit marker.
Yes,
Now
I
you
see.
it's
I see
506.
that. Thank you.
Okay, thank you. Here, I move Exhibit 506 into evidence. I would just highlight those 2 pages.
No objection.
Exhibit 506 is received, permission to publish granted, and which 2 pages again?
Page 3 and 6. Now, Ms. Eisenhart, on this item, under the highlighted section on page 3, you did an analysis for Lynn Hernan again as well, correct?
Yes, that's correct.
And you came to the conclusion for support for different sources for this, correct?
Yes, support for different sources compared to Lynn Hernan's known writing.
Thank you. If we could go to page 6 then, please. Again, you analyzed this highlighted portion, correct?
I did, yes.
And again, similar question. In this set of analyzed writing, you came to the conclusion that there was support for different sources for Lynn Hernan writing, correct?
That's correct.
If we could go to Exhibit 508, please. This is item 6, and if we could just scroll through that document, please. Ms. Eisenhart, do you recognize that document?
I do.
And that was item 6 of question documents that you reviewed.
Yes, that's right.
Here I move into evidence Exhibit 508.
No objection.
Exhibit 508 is received,
I'd be asking to publish that to the jury too.
granted.
This highlighted portion, Ms. Eisenhart, on top of page 1. Again, did that come back with support for different sources for Lynn Hernan's writing?
Yes, that's correct.
Okay, going to page 2, please. And I want to direct your attention to the signature on this page. Did that also come back for different, or support for different sources for Lynn Hernan's signature?
Yes, that's correct.
I want to take us back to Exhibit 503 and moving on to Ms. Kurczewski's part of the report, and take us to the first page, please. Again, you looked at this highlighted portion for Ms. Hernan's handwriting earlier, correct?
Yes, I
But
did.
you also analyzed it for Ms. Kurczewski as well, correct?
Yes, that's correct.
In this portion of Exhibit 503, you came to the conclusion that there was support for different sources for Ms. Kurczewski's handwriting, correct?
Yes, that's correct.
Now, I want to direct your attention to the very top of Exhibit 503. Can you see the portion where it says Jessy rewrote, comma?
Yes, I see that.
Does that seem to correlate with the conclusion that there would be support for different sources for this written text?
Are you asking me if that comment influenced my opinion?
I'm talking about just generally speaking, do those two opposing views go together?
The content of that information was not something that I took into account when I did the handwriting comparison.
Okay, so you didn't take that into consideration, but if someone told you that they rewrote it, but then you came to the opinion that there was support for different sources, again, that doesn't seem to make sense, does it?
Well, I don't know who wrote that information. And again, I have to use the known writing as the evidence to do the comparison. So the known writing that I had for D when I did the comparison to this question portion was inconsistent.
If we could move on to Exhibit 508, please. Yes, please. No, we're all. And if we could go to page 1, please. The highlighted portion, again, you conducted your analysis about Ms. Hernan, correct, earlier?
Yes, that's right.
You did the same with Ms. Kurczewski in this case, and ultimately your opinion was a support for common source for this highlighted portion, correct?
This is item 6, right?
Yes.
For the comparison with Jessy, yes, I gave a support for common source for this highlighted portion, excluding the Lynn Hernan signature that's placed in there.
Okay, thank you. If we could take that down, please, and just show the witness Exhibit 507. And if we could scroll that through that briefly. Do you recognize this document as item 5 in the question documents that you reviewed?
Yes, I do.
Your Honor, move Exhibit 507 into evidence.
No objection.
Exhibit 507 is received, permission to publish granted.
Ms. Eisenhart, we've seen this well previously before you were testifying, but the reason I wanted to point this out again is there are highlighted portions of this, correct?
Yes, that's correct.
Okay. And looking through this entire document, including the text and the signatures, What was the conclusion that you came to in this item
With respect to which writer?
with respect to Ms. Kurczewski?
Item 5. I gave an opinion of support for common source for the signature and the handwriting, excluding on the second page the
If we could
Jennifer Flower and Lynn Hernan signatures at the bottom.
So if we could scroll down to page 2. So if we could just stop right there.
Oh, I'm sorry. Excuse me. May I add?
Yes.
That also excluded the characters that are underlined and capitalized in this document. So I actually examined more than just the highlighted section to my recollection.
Perfect. I think you had mentioned if we could scroll down to page 3, please. The highlighted portion for the Lynn Hernan signature. Do you see that correct?
I do, yes.
In terms of that, did you came to the conclusion that there was support for a common source, that Jessy wrote that correct?
That's correct.
Thank you, Ms. Eisner. I have anything else?
Any redirect?
Yes, Your Honor, I do.
Go ahead.
Ms. Eisenhart, when it comes to the questions you were asked about the carbon copy checks, do you remember that line of questioning?
Yes.
You don't have any knowledge of whether Ms. Hernan had a checkbook with carbon copy checks, do you?
I do not have any knowledge of whether she did or did not.
And you know that some checkbooks do not have carbon copy checks, right?
Yes, that's correct.
If there were carbon copy checks that were, if the state had carbon copy checks for Ms. Hernan, would you have wanted to see those carbon copy checks?
Yes, I would have.
And you didn't get any carbon copy checks, right?
No, I did not.
We talked about what items you compared for Jessy. And you said that some of the writings, of course, were done in a controlled setting, right?
The known writing of Jessy's, yes.
In other words, there was, it would be accurate to say that Jessy sat in a room with police officers or agents and did a number of writings for your purpose.
Yes, that's correct.
But that's not all the known writing you had from Jessy, isn't that fair?
That's fair.
So for example, could I pull up on the screen, please, Madam Clerk? I'm going to show you what, can you see on your screen yet?
No, not yet.
Let me know when you can.
Okay, I can see the screen now.
Do you see Exhibit 515?
Yes.
And this is a one-page document. Is this one of the items in your, that you were given in your evaluation of Jessy's handwriting?
Yes, I use this item as known writing of Jessy.
Is this item 13?
Yes, it is.
And this wasn't something that was done in that controlled setting. This came to the FBI in a different way. Fair?
That's how I interpreted it. Yes.
I'll move for admission. I honor of item 13 or exhibit 515.
Of item 13.
Item 13, exhibit 515.
No objection.
Exhibit 515 is received. Seeking to publish?
Yes, please.
Go ahead.
And it's not, you're not involved in any kind of probate case here, are you?
No, I'm not.
This appears to be something having to do with the estate of Lynn Hernan. True?
That's what it appears to be. Yes.
Okay. Did the jury ever get that up on their screens? Okay, great. All right, then I would like to show you item 14. Exhibit 516. Is this another document? Let me show you. I'm sorry, it should probably be removed from the jury. Yes. I'm showing you what's marked as item 516. Is this a 2-page document?
Yes.
Do you recognize this as a document you were provided with by field agents?
Yes. This was also a document provided to me as known writing of Jesse's.
And this would be item 14 on your list?
Correct.
You're going to move for admission of exhibit 516, request to publish.
No objection.
Exhibit 516 is received. Permission to publish is granted.
So in other words, this is another document that you had of Jesse's that you could use to compare.
Yes, that's right.
Just make sure it publishes for the jury and then I'll move on. And you had, in addition, a 1-page document that was submitted that you labeled item 15, true?
Yes.
Could I remove this and I'll show the witness one more exhibit?
Go ahead.
Do you see exhibit 517 here?
I do.
And this is a 1-page document. Is this your item 15?
Yes, there does seem to be some distortion to the image that I don't recall from when I examined it, but this is a copy of that document that I received.
And so another known writing that you had for Jessy.
Yes.
Move for admission of 517.
No objection.
517 is received.
No need to publish. I'll show you also item 16. Do you see exhibit 518 noted on this?
I do.
This appears to be 2 pages, is that right?
Yes.
Is this one of the other documents that you had of known writing of Jessy?
Yes, it is.
Move for admission of item or exhibit 518.
No objection.
Exhibit 518 is received.
And lastly, on the known writings, let me show you what is marked as exhibit 519 and is 2 pages. Do you recognize this document?
Yes, I do.
This is item 17 in your list.
Yes, that's right.
And this is another document that you were able to evaluate when deciding whether writing was Jessy's or not.
Yes, this was additional known writing I could use for my comparison.
And this appears to be a letter she wrote to a judge. Is that right?
Yes.
Move for admission of exhibit 519.
No objection.
Exhibit 519 is received. Permission to publish if needed is granted.
Yes, no need to. We've shown the jury enough. You were asked questions about Jessy admitting to writing checks. Remember that line of questioning?
I do.
In interviews that this jury has heard, played in this courtroom, Jessy said that she may have written some checks for Lynn while she was in the hospital. Did the state tell you anything like that?
No, not that I recall.
Does that affect your opinion in any way?
No, it does not.
There's nothing in the interviews that Jessy admitted writing all of these checks.
I'm not aware of any information about the interviews.
You said that even on some of the support for common source opinions involving Jessy, that there's limitations. What kind of limitations are there?
So with regard to the opinions of support for common source with Jessy, I'm going to refer to my report if that's okay, Your Honor.
Sure. Right. Yes.
So as I mentioned with the checks that we had some photos of yesterday on the screen, those of course are limited in their clarity and detail. They're low resolution images, and there are times when it's hard for me to see how characters are formed, how they may be connected, if they're connected, if they're broken, or if that detail is just lost in the reproduction of those images. That's one of them. And the other limitation with respect to the support for common source conclusions, that's what you were asking me about, right?
Yes.
Is the presence of unexplained characteristics. So an unexplained characteristic is something that is observed, well, a characteristic observed in the question document that whenever I examine the known writing, I can't seem to account for it in the known writing. It's either inconsistent, I may not have enough examples of it, or have enough variations of it. So that's another reason why I am not able to perhaps reach a source identification in those cases.
Okay, thank you. You were asked about Exhibit 506, Item 4. I'm going to bring that back up again on the screen for everyone to see. It's already in evidence. And I direct your attention to this exhibit. Do you recall this?
I do.
This would be Item 4. It's a letter. If we look at page 7 on this particular letter, did you reach a conclusion?
I did.
And did you reach a conclusion as to whether Jessy wrote Lynn? I see Lynn is highlighted. Did you reach a conclusion as to whether Jessy was the author of the highlighted word Lynn?
So I examined all of item 4, which was many pages, and my opinion with regard to whether Jessy prepared that was a support for different sources, and that included the Love Lynn salutations. Again, there are limitations why I'm not able to reach a source exclusion in that case.
Okay, that could come down while I bring up another item that you were asked about. When you were asked previously about item or exhibit 508, item 6, do you remember those questions? And you were asked to give an opinion about the highlighted area that I'm showing on page 1. Do you remember that?
I do recall the questions. Yes, I don't see anything on my screen. If
Oh, you don't?
No,
Okay.
if you're trying to show anything.
Apologies, I should have said so. It should come up in a minute.
I see it now. Thank
Do you
you.
remember this exhibit?
Yes.
When we go to page 2 of this exhibit, did you reach an opinion about the signature of Lynn Hernan as it relates to Jessy?
I did reach an opinion.
And what was that opinion?
So in
This
the
could be published, Madam Clerk, because we have already introduced it.
I was inconclusive with regard to whether or not Jessy prepared the highlighted signature on item 6.
Thank you. That can come down. When you were talking about excluding characters and more than just highlighted sections, what do you mean when you say that kind of give that kind of an opinion?
So whenever I'm giving an opinion of, let's say, a support for common source, if I say excluding whatever that content is, that means I'm not giving a support for common source for that part that I'm excluding. And in the following conclusions in my report, I would have addressed that excluded portion. So in the example of item 6 that we just talked about, I gave an opinion with regard to whether Jessy did or didn't write it, excluding the Lynn Hernan signature. And later on in my report, I came down a little further down the page and gave an inconclusive opinion for that.
And just pulling up for your, if we could pull up on the screen the item that's already been admitted, Exhibit 523, item 21. Can you see that on your screen?
Not yet.
Okay.
Oh, here it is. Okay. I can see it now. Thank you.
All right. Your opinion, I think you said before, was that Lynn Hernan, there's a support for Lynn Hernan having prepared the handwritten text of item 21, exhibit 523, and the signature at the bottom. Did I understand that correctly?
Yes, I said support for common source that Lynn wrote the questioned handwriting and the signatures, the Lynn Hernan signatures on this item.
Why are some of these items, why do some of the items that we've been looking at this morning have yellow highlighting on them? Who did that yellow highlighting?
I don't know who did the highlighting, but when I initially was assigned this case, I contacted the FBI contributor and noted that the quantity of examinations that he was asking me to do by the trial deadline was going to be very challenging for me to be able to complete all of that. And I asked if perhaps there were parts of the documents that we could limit my analysis to that would be helpful and also timely in providing a report to the contributor.
Okay, thank you. That's all I have.
All right. Thank you, everyone. We are going to take our morning break. Ma'am, you may step down. And all rise for the jury, please.
Okay, I can't remember if we've had a sidebar. I don't remember. any so far.
I'll take that. Thank you. And I don't think she's under any other subpoena, correct? All right, she may be excused then. I know the state was attempting to ask a question, but under 90611 and being the defense witness, I'm not going to allow recross. So we'll take our break, about 15 minutes, be back here. Thank you. We're in recess. Oh, well, before we go, I wanted to ask the defense about the three witnesses I said I'd ask you about in the morning, Kareem Poza, Jim Kelleher, and Scott Craig.
Excused.
They are all released from their
Released.
subpoenas. All right, thank you. They can, please advise them.
Thank heaven
All right.
for that. Okay. So we're not going to be subjected to three more of the defense people. Let's see if we've got anything. Looks like Josh has got another video on recorded call with the detective in Roy. He said Roy City, but I've never heard it called Roy in all of my life. Let's see. Let's see. They're on jury watch over in the take care of Maya trial. Let's see. Let's see. We've got a post on Common Sense True Crime community tab, which says the Wells boys are happy and safe. They are where they need and want to be. Dawn and Candace are not getting the boys back. There was a period after they were removed from the Wells house where the Wells could have tried to get them back. That was over 2 years ago. The state doesn't allow parents to keep trying for years. The time is up for that. The boys are being put first. Their safety, development, and stability matters. This went on for years. Possibility that they may have to go back there to Ben Hill. No, Ben Hill. Would be traumatic and unstable for them. Dawn and Candace are not getting their boys back. Boys, you are safe from parents who abused and neglected you. I wish boys blessing on top of blessings. Hope you find healing for what they've been through. Do we know if their parental rights have officially been terminated? I hope so, but you know, things are sealed in family court, so Let's see. What else have we got today? I got a new video from Bruce Rivers that looks interesting called When Evil Parents Realize They've Been Caught. Always interesting to hear what he has to say from his perspective as a defense lawyer. Interesting. We've got a video from Michelle after dark on Indiana Defender Council weighs in to snooker judge goal. I'm going to have to watch that. Oh, we're not seeing a lot here today. What else? What other trials have we got going on? Oh, yeah, the husband hit and run murder trial, also in Wisconsin. Let's see. Let's take a look at that. Oh, nope. It says requires a fee. Not doing that. Okay. Okay. Let's dip in. I don't know why it said that we needed to pay. We listened to the 911 call yesterday on this case. Ah, yeah, it's wonderful having technology. We
Mr.
don't-
Zachard asked you about where you had located the fiber or apparent fiber on this particular location. Can I ask you why you would look in a location like this for a fiber based on your training in evidence collection?
We looked at the entire underside of the vehicle. It just so happened that that's where we located a fiber, an apparent fiber.
Is there anything special about this particular area that would tend to collect fibers?
There's sharp corners on it, which collect things like that.
He also talked about other things that were collected. Were there items that you did not collect?
Yes.
And why was that?
We photo documented and scaled item number 4. Taking a gas tank off to collect it would have been a lot of work. There's not a whole lot we could do with the actual item. Anybody that would look at it later on can do the same analysis that they'd be able to do with just a scaled photograph.
Also hazardous probably to transport a gas tank?
Yeah.
Your Honor, I have no further questions. Thank you.
Recross? Just one. Mr. Nollet, is it correct that, to your knowledge, no analyst actually examined your photographs of item number 4?
I don't believe anybody did.
Thank you. We redirect from there. All right. Thank you. You may step down. Why don't we take a morning break? You can go ahead.
Okay, a morning break.
We'll take a morning break till 10:30. We'll try to get going right away if we can. Please don't talk about the case, and we'll see you then.
Okay, well, so I guess Wisconsin, we're all into taking breaks here at the same time. Okay, let's switch back to our flagpole and see if there's any short clips in the meanwhile. Somebody commented on the chat there. It says the breaks are more exciting than the trial. That was pretty bad. Oh dear. Let's see. Shouldn't have long. We've only got a minute left until they're theoretically supposed to end the break. I got some good stuff, but on my saved list, but not anything I want to get into. So with so little time.
Be seated. I can reorganize myself over here.
Okay, here we go.
Double check. I don't think we have any more of those. I've got 501.
I hope that the next witness is more interesting or even better if the state rests.
Probably- I'll just keep the one that's. This needs to go back.
I mean, the defense.
No, I didn't.
So wait, these are yours or these going?
No, I'm just, can you just double check that the others were not offered? I'm just gonna put them in a different pile there.
I'm just so glad that they're skipping 3 defense witnesses. Please, just rest. Rest already. It's a 15-day trial was what the projection was, and we are on day 12, and I'm just ready for this one to be over. I don't want any really long trials coming up because case Sarah is coming up in just over a month. So I don't want any
And for some reason,
really long trials.
there's one I didn't have. It's got stuff. No, it's stuff. I got it.
Seems like they came back with the camera a little too early. Yeah. If I were poisoning somebody, I wouldn't be buying Visine. I'd be going to the dollar store, get it cheap. I just didn't find that credible about the defense witness yesterday. He said he saw several bottles of Visine, and they asked, were there other brands? No, it was Visine.
Can we find that?
Lynn was a bargain basement person. She isn't going to be buying the name brand. And Jessy seems like a cheapskate since she's always taking money from
Has the witness been located? Okay, good.
Lynn. So why would she pay top dollar when that just leaves less money for her to spend? I think it was a created memory because of Jennifer Flowers going on and on about all of the bottles of Visine all over the place, and after a while he came to believe he saw it too. I'm
All
not
right, let's go back on.
buying
The
it.
record appearances are as they were before. The defense have the next witness available.
Yes, Judge, she's.
I'll go get her.
All right, well, we need to bring the jury out first.
She's in the courtroom, Sarah Trump.
Okay, and anything we need to address prior to bringing the jury in from the state?
No.
From the defense?
No, Judge, thank you.
Okay, very well. Madam Clerk, go ahead.
Get ready.
Judge?
Yes.
Okay. This is 2/6/24. Is one of them for the box and one's for Judge?
Yes, I put one in.
Are we all looking at our handwriting now? Because I know. Like, oh, look what I did here. What do we got? Okay. And then I have the other ones that didn't get offered. Yes, that's good. And then here's some of the other ones. I don't need this because it's just something for me to. You have quite a few to add to your list today. Just
Oh,
this
yeah,
morning.
they're right. But I had them all. They were on the original fund sheet. So
Ah.
we have
I bet.
half the face. Half the face is so much more expensive.
Excellent. All right, thank you, everyone. Please be seated. And Attorney Galaviz, you may call your next witness.
Thank you, Judge. Defense calls Sarah Trump.
All right, good morning. If you would please make your way to the witness stand. It is on my right, all the way to the front, up one riser. When you get there, please remain standing, raise your right hand. And my clerk, Teresa, who's all the way to our left, will swear you in.
Do you solemnly swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. You have a seat.
First thing I will ask you to do is to state your
First and last names for the record and spell each.
Sarah Tromp, SARATROMP.
All right, thank you. Go ahead, Attorney Galaviz.
Thank you, Judge. Sarah, you're a nurse, correct?
Yes, nurse practitioner.
Would you prefer that I call you just Miss Trump?
Yes, please.
And you used to be called Miss McGrath?
Correct. Maiden name.
And you're currently employed, correct?
Yes.
Where do you work?
Freighter in the medical college.
What do you do at Freighter?
I'm a nurse practitioner in neurosurgery.
And how long you been working there?
5 years.
Was there a point in time that you worked for pain management?
Yes.
And when did you work at pain management?
March 2017 through November 2018.
So in November, you shifted over to Freighter?
Correct, yes.
And while you were working at pain management, were you a nurse practitioner?
Yes.
And as a nurse practitioner, are you allowed to prescribe
Yes.
medication?
Correct, yes.
Are nurses allowed to prescribe medication?
Not an RN, but an advanced practice nurse practitioner.
So you're an advanced nurse.
Yes.
And again, you were an advanced nurse at pain management.
Yes.
And at pain management, what is that? What kind of facility is that?
A clinic and ambulatory surgery center that does medications and interventional pain management.
At pain management, what kind of patients did you see? Did you see patients that were referred to you by other doctors?
Yes.
Were you see patients who just walked in?
Yes.
And in 2017, did you see a patient by the name of Lynn Hernan?
Yes.
Was she a patient of yours?
Yes.
Was she assigned to you when you were at pain management?
Yes.
So if Lynn Hernan wanted to see somebody at pain management, she had to make an appointment with you.
Yes.
I'm showing you what's marked as Exhibit 540. And can I publish the searches that have already been moved into evidence?
Go ahead.
Do you have it on your screen yet?
I do not.
So I'm going to scroll over this exhibit just to make sure that you are familiar with it. It's a 39-page exhibit. Am I going too fast for you, sir? Or Ms. Trump?
No.
Oh, so you've seen that exhibit before, right?
Yes.
And you reviewed it prior to your testimony, correct?
Yes.
And Exhibit 540, is that a copy of a record on Lynn Hernan that you had at Advanced Pain Management?
Yes.
And Ms. Hernan came to you because she was in pain, I take it.
Yes.
And the records indicate that she's been in pain since 1991?
Per the records, correct, yes.
And you began treating Ms. Hernan according to page 36 of the record, your first contact with her, correct? On July 10th, 2017, correct?
Yes.
So you don't remember Ms. Hernan, do you?
Not specifically.
She doesn't stand out to you as a patient that you saw?
No.
But based upon the record, you know you treated her.
Correct, yes.
And in 2017, July, why she came in and what you treated her for would be reflected in the record, correct?
Yes.
And on July 10th, 2017, page one, she was complaining of low back pain?
Correct, yes.
Was she complaining of anything else?
As it states in the record, low back pain and weakness in the legs.
Did you treat her for the low back pain?
Yes.
And what did you prescribe medication?
Yes.
What did you prescribe?
Over the course, per the records, over the course of treatment with Lynn, tizanidine, Butrans, hydrocodone, cyclobenzaprine, and baclofen.
Over the course of your treatment?
Correct.
But on July 10th, 2017, you didn't prescribe that, did you?
No.
Where on this document would it indicate what you prescribed there?
I believe it would be on page possibly 38, a little bit lower. Possibly 39, apologies. So it looks, per the records, July 10th, no medications were prescribed, but an MRI lumbar spine was ordered.
And on page 38 of the report, it mentions the word oswestry, correct?
Yes,
What is that?
that is a self-reported function scale for patients of their everyday activities when patients that have acute or chronic low back pain.
Is it safe to say that everything, when you're treating Ms. Herndon, you treat her as to what she's reporting to you as far as her pain, her problems, correct?
Correct.
And regarding the score, she indicates that she's a 35 out of 50.
Per the records, yes.
You know, but again, she's telling you that, correct?
Yes,
You don't know for a fact that that's, if she's a 35 out of 50, correct?
it is self-reported. Yes.
Okay. Ms. Trump, I'm going to show you an exhibit 66616. And tell me when it's up on your screen.
It is, yes.
Are you familiar with this exhibit?
Yes,
It's a two-page exhibit. Would you agree?
yes.
Judge, I moved this exhibit into evidence and I asked it to be published.
No objection.
Exhibit 216 is received, permission to publish granted. 616, sorry, thank you. I don't know why I wrote down a 2.
You have to wait until the screen comes up with the jury. Ms. Trump, this is what you're referring to as the oswestry score?
Yes.
And this is, what is this?
This is a self-reported tool that patients use to report their function in their everyday activities when they have low back pain.
So page 2 of the exhibit is something that the patient has to fill out.
Correct.
And they fill out, I take it this questionnaire the day they come in.
Yes,
Is it prior to you seeing them or after you see them?
during intake prior to me seeing them.
And these questions are asked to fill out pain intensity, correct?
Yes,
Personal care, correct?
yes,
What's 3? Lifting?
lifting.
And they're asked to mark checkout boxes, correct?
Yes,
And again, the patient themselves are the ones who fill this out.
yes.
Again, self-reporting.
Self-reported, yes,
They're asked about their walking,
yes,
5 sitting,
yes,
6 is standing. And again, as Ms. Herndon is going through this questionnaire, she's marking boxes.
yes,
She's asked about her sleeping, correct?
yes,
And in sleeping, she's asked certain questions, correct? Or certain boxes are there for her to mark.
correct, yes,
And the boxes consist of pain does not prevent me from sleeping well, correct?
yes,
Down from pain prevents me from sleeping at all, correct?
correct.
Talks about her social life.
Yes.
Why is that important? Why does a patient get asked that?
If someone's in pain, it can inhibit their everyday activities, and social life is a part of everyday activities.
Again, as far as number 1, pain intensity, there's certain boxes that she needs to mark, correct?
Yes,
I can tolerate the pain I have without having to use painkillers, correct?
Correct.
That's like from 1 to 10 scale almost, correct?
I believe so, yes.
The last box is painkillers have no effect on the pain and I do not use them, correct?
Yes.
And again, Ms. Harnan filled out this questionnaire before she saw you, correct?
Yes.
And on the scale, she considers herself, at least on July 10th, 2017, a 35.
Yes, per the records.
And below the scale, it talks about what no disability is, correct?
Yes.
Mild disability, moderate disability, severe disability, completely disabled, correct?
Yes.
And it gives a description.
Yes.
And Ms. Hernan, in this case, as far as self-report, she thought she was moderate, correct?
Per the records. Per my records.
Well, she reported a 35,
Yes.
which would place her completely disabled.
Yes.
It also says these patients are either bedbound or exaggerating their symptoms.
Per this scale definition, yes.
You know, you saw her again, I take it, from 2017 to 2018, correct?
Yes.
She was your patient on those visits, correct?
Yes.
You can't recall how many times you visited her, correct?
I would have to refer to the records.
Again, on page 616, or exhibit 616, right before the instruction part, it talks about that this test has been used for a while, correct?
Yes.
It's been around since 1980,
Yes.
and it's considered the gold standard
Per this document, yes.
for low back pain functional outcome tools, correct?
Yes.
Going back to exhibit 540, which has been received by and published already. You saw her again, according to the records, on August 1st, 2017, correct?
Yes.
And on August 1st, 2017, did she have to fill out this questionnaire again?
I cannot recall it.
Is that a requirement that every time you see a patient, they have to fill out this questionnaire, or sometimes they don't?
I cannot recall on the intake.
But on August 1st, she came in, there's just a follow-up,
Yes, correct.
and she again was complaining about her back pain.
Yes.
And as far as history of present illness, you reviewed that when you're talking with her?
Yes.
And again, she continues to talk about her back pain and
Yes.
any other pain?
Per the record, it says there's weakness in low back, hips, shoulders, right knee.
Does it indicate the pain makes the patient feel frustrated?
Yes.
And your assessment when you saw her on page 34 of the exhibit, you gave an assessment after you treat. treated her?
Yes.
And what was your assessment?
So per the records, following up on to review the MRI and discuss treatment options. And says patient states she has a lot of muscle spasms in her legs and low back at night that affects her sleeping.
So she's complaining about her sleeping.
Yes.
Is she also on that page informed you that she's been in pain since 1991?
Yes, per the records.
And in July 10th, 2017, when there's an area where it refers to bear with me. But in a lot of these documents, they go over a list, like you have any problems with your eyes and things like that, correct?
Yes.
And in July 10th, 2017, she was asked and she said negative.
I would have to refer to the document.
I missed on the assessment on the second paragraph. Again, the date is August 1st, 2017, correct?
Correct.
But she reports on that same sentence that she had fallen.
Looks like per the records, she had a fall on July. Can I clarify if that's the 16th or the 18th, 17?
And apparently the fall increased her pain.
Correct, yes.
Again, self-report.
Self-report per the records.
She was again seen at that clinic, according to the records, on August 16th, correct?
Yes, correct.
2017. But on that date, she was treated by Dr. Young, correct?
Yes. For an injection.
So you prescribed an injection for her.
Yes.
And the injection was for pain?
Yes.
Is it true you also tried patches with her?
Yes.
And again, for pain?
Yes.
And the patches, do they have, the pain patches, do they have any kind of substance in them?
They do. It was the Butrans patch, buprenorphine.
Is that an opiate or a benzo?
An opioid.
And her next visit at the clinic was on September 12th, 2017, again with Dr. Young, correct?
Yes.
What was the reason for a second visit with Dr. Young?
Per the records, it was another injection.
And in the history section that she reported to on that visit, she talks about her last visit, correct?
Yes.
And what does she state about her history?
Per the records, and this is the procedural notes, so Dr. Jung, patient states 10% relief.
And she self-reports that the pain 5-10 at best, 8-10 at worst. She's currently a 6-10.
Yes.
And that's again the visit with Dr. Young on page 26 of the exhibit, correct?
Yes.
On September 26, 2017, she visited your clinic again, correct?
Yes.
And this time she was treated by you again.
Yes.
And the reason for the visit, is it listed on page 1 of that exhibit?
Back pain. Yes.
Again, she still is having back pain.
Yes.
She again, where she reports moderate severity, is it self-report? Is it?
Self-report, yes.
And she indicates that it's getting worse.
Yes.
That it occurs persistently, correct?
Yes.
And she describes where she's getting the back pain, correct?
Yes.
What does the exhibit say that where she is receiving the back pain?
Location of pain is lower back and gluteal area.
And right below that, there's a pain details, correct?
Yes.
There's a pain score. It's a 6. It says pain score at best is 6, at worst is 10, and she's currently 6 out of 10, correct?
Yes.
Again, I was talking to you about that scale where it discusses like eyes and respiratory. On September 26th, when it talks about her eyes, it's negative, right?
Per the records, yes.
And this, you see this review of symptoms like in July 10th, in her prior visits, July 10th and August 1st, where as far as her eyes, she was indicating, at least in this visit, September 2017, that she has no problems with her eyes and no pain, correct?
Per this page, yes.
At least this part of her, this time in her life, she's not complaining about her eyes.
Per the records, yes.
But it does list as far as her weight, correct?
Yes.
What does she report as far as her weight?
199 pounds per the records.
And on this visit, do you prescribe any medication for her?
I would have to reference the
Would it be at the bottom of the screen?
The plan, yes. Yes, this right here.
Did you prescribe?
Yes.
What did you prescribe?
Per the records, the tizanidine increased to 3 times a day as needed for spasms, and then started the Butrans patch.
Is that the patch you refer to?
Yes.
And that's the one that has opioids?
It's an opioid agonist antagonist.
And it talks about these two medications along with her smoking in asthma can cause, what does that sentence say?
These two medications, along with her smoking and history of asthma, COPD, can cause respiratory depression and increase her mortality rate threefold.
What is that?
So when taking an opioid and a benzodiazepine concurrently, that can increase respiratory depression or decreased breathing.
As far as you had an assessment, correct?
Yes.
And on page 24 of the exhibit, it talks about your assessment of her, correct?
Yes.
And the last paragraph, you mentioned she reports that she does PT every day at home, correct?
Per the records, yes.
And she is unable to make appointments because she has so many doctor appointments to go to.
Per the records, yes.
And per the records, on page 18 of this exhibit, you see her again, correct?
Yes.
And this is on October 9, 2017.
Yes.
And as far as chief complaint, she again is complaining about her back.
Yes.
It talks about her back pain severity levels, correct?
Yes.
Moderate to severe.
Yes.
She indicates to you self-report that it's getting worse.
Yes.
Again, it's occurring persistently.
Yes.
She describes where she's suffering as far as back pain.
Yes, per the records.
She again describes the pain as being burning and throbbing.
Yes.
When a patient tells you that the pain is burning and throbbing, as her treatment provider, what is she describing to you?
It's a pain descriptor, so pain can be all different types of burning, throbbing, sharp shooting, an adjective on how she perceives the pain.
And again, on the pain details, the pain score, 6 being best, and at worst, I'm not sure if it's a 6 or 8. She's currently 8 out of 10.
Per the records, yes.
So in comparison to her other visits, she's getting worse as far as self-report.
Correct, per self-report, yes.
Again, in that area where she discusses her eyes, again, she reports negative, correct?
Per the records, yes.
No dry eyes, no eye pain.
Per the records, yes.
As far as her assessment, you list the referral by Dr. Smith, correct?
Yes.
Had you been in contact with Dr. Smith?
Per the records, I believe there was a conversation between her and I.
And do you know who Dr. Smith is? In relationship to Ms.
Her primary care provider who referred the patient to me.
And in this assessment, she's complaining about weakness in her legs,
Yes.
numbness, correct?
Yes.
The pain is aggravated by all her ADLs. What is that? What's she referring to?
Activities of daily living.
She continues to say pain relieved by swimming, medication, but she also reports, what does she report in her assessment there?
Loss of bowel and bladder since her GI issues 2 years ago, per her report.
Do you prescribe medication on this visit?
Yes.
This is page 21 of this exhibit. Does it list what you prescribed?
Yes. Norco.
The patch?
No. Norco hydrocodone, a pill.
What's that? What's hydrocodone? Is it an opioid or benzo?
An opioid.
You apparently treated her again on December 7th, 2017, correct?
Yes.
December 4th, I'm sorry, 2017, correct? And again, she complains about pain and
yes.
It says severity level is moderate, severe. The problem is changing in character. What is that? That's what she's reporting to you.
Changing, yes.
It's still persistent.
Yes.
She describes the pain as ache, sharp shooting, stabbing. Correct?
Yes.
Here, her pain score is 6 out of 10, correct?
Yes.
Again, self-report?
Correct.
We'll review the symptoms on this exhibit.
Yes, per this record.
So on December 4th, 2017, she says her eyes are dry and she has pain in her eyes. By you after you talk with her?
Yes.
So this is your assessment of her when you treated her each time.
During the office visit, yes.
And on December 4th, 2017, what was your assessment?
Per the records, giving her adequate pain relief, but was receiving other can increase her risk of respiratory depression. And per the record, I spoke with her primary care provider a few weeks ago, and I will be stopping the hydrocodone so that the primary care provider can continue to prescribe the alprazolam for her anxiety and sleep without the concurrent risk.
In the next paragraph, you again continue your assessment, correct?
I believe so, yes.
opioids or the benzos?
The hydrocodone is an opioid and the alprazolam is a benzodiazepine.
And again, it's, a patient shouldn't do that.
They can increase the risk of respiratory depression when taken together.
And do you discuss a plan with her?
Yes.
And what's the plan? And prior to this date, you had never prescribed cyclobenzaprine.
Correct.
Why did you feel cyclobenzaprine was going to help her?
She had reported muscle spasms and the low back pain.
His record on January 20. The same reporting that she did on other visits.
Yes.
On the pain score, it's 7 out of 10.
Yes.
That's what she's indicating to you.
Yes.
Again, on this visit in January, she talks about her eyes again, or reports that her eyes are still dry and she's still in pain.
Yes.
Again, you assess after she leaves, and what is your assessment of?
Per the records on January 29th, reports such bad welts all over her body and organ distension yesterday. She tried the cyclobenzaprine for her muscle spasms in December, but stopped at 1/8/18 due to increased weight gain. She also reports a bad headache while on this medication. It interrupted her sleep. She woke up 2 hours after 2 hours versus her normal 4 hours of rest. She is wanting to try one more medication, even though she commonly gets adverse effects to medications.
So on that visit, she reports to you that she's allergic to cyclobenzaprine.
Per the records, side effects. Yes.
And she stopped. And again, cyclobenzaprine is a what kind of substance?
Muscle relaxant.
Opioid or benzoid?
Non-opioid.
Do you formulate a plan?
Yes.
And what is your plan with her?
Discontinue the cyclobenzaprine and start metataxalone, which is a muscle relaxant as well.
Here at the plan, it talks about a test, correct?
Yes.
What does it say about a test?
Urine drug screen on September 26, 2017, appropriate for alprazolam, but inappropriate for temazepine, not prescribed to her.
So according to your examination of her, she is not taking her medication as prescribed.
Per the records.
On that same exhibit where we're talking about her eyes are being positive for dry eyes and eye pain, there's a area that talks about, is it psych?
Psych.
What is that?
So review of symptoms, psychological system.
She there reports anxiety and insomnia.
Correct, yes.
Again, insomnia is not being able to sleep.
Yes, correct.
The next time you see here is February 28, 2018, correct?
Correct, yes.
And her chief complaint continues to be back pain.
Yes.
The pain is still persistent, lower back. It's gone to her hips.
Yes.
On its pain score, I think here she says 5 out of 10.
I believe so, yes.
But she says the pain again is shooting and stabbing.
Yes.
Regarding the eyes, she continues to report that she has dry eyes and
As a Pam, along with ethyl glucuronide. Because of this, the patient has been discharged from that practice due to noncompliance with urine schema.
so based upon your assessment, she's again not complying with her drug medication.
Per these records, yes.
She was discharged.
Correct, yes, per these records.
What is this opioid risk on page 8 of the exhibit?
The opioid risk tool, risk assessment tool, is a self-reported tool to assess patients' risk of opioid misuse or use.
It says the patient signed a controlled substance agreement on September 26, 2017. What is that? What is she signing?
So whenever the practice or provider was going to be starting a controlled substance, the patient had to sign an agreement outlining the terms of being compliant with a controlled substance.
And after your assessment, you formulate a plan again with Ms. Hernan, correct?
Yes.
And what was your plan?
Start back as needed for muscle spasms for 2 weeks. And also,
It talks about here on your plan, a referral.
yes, so to Dr. Papandrea, but that she has seen a psychologist before with no results.
So you want her to see a psychologist?
A pain psychologist, correct, yes.
And in here, on page 9 of the exhibit, that's where it says you prescribe baclofen, correct?
Yes.
You saw the patient again on March 14th, 2018, correct?
Yes.
Ms. Hernan, correct?
Yes.
And still the back pain, correct?
Yes.
Or the back pain complaint? Correct?
Yes, yes.
And you had prescribed the baclofen to treat the pain, correct?
Yes.
And the baclofen is what kind of controlled substance?
It's not a controlled substance. It's a muscle relaxant.
She talks about the pain being piercing, shooting, correct?
Yes.
Pain score, again, 5 out of 10.
Yes.
On the top of page 3, it describes the baclofen. It has the word rash on it.
Yes.
Is that what she reported to you?
Yes.
Again, on the eye section, it talks about dry eyes, eye pain. It's still happening, correct?
Yes.
Are you doing any treatment for those?
No, I am not.
And you have an assessment for her, correct?
Yes.
And what is your assessment on March 28th?
Here today, March 14th, 2018, for follow-up office visit, she tried the baclofen for her muscle spasms, but she broke out into a rash on her abdomen, so I had to stop this. She established with a new primary care provider who she likes and who refilled her nighttime alprazolam. When asked about non-medication pain relief modalities to try, patient reports that she does daily exercises with the bands that she got from PT.
So it talks about allergies, correct?
Yes.
She mentions at the bottom of page 2 what she's allergic to, or is it something you found out yourself? Is it self-report?
Either self-report or from outside records.
So her records, follow-up records that you have indicate these allergies, correct?
Yes.
Again, and that's where she indicates one of her allergies is baclofen, correct?
I believe that was added once she had tried the medication trial per the records.
These other allergies that she's allergic to, where are they?
a variety of medications, fluticasone, which is, I'm not as familiar with these medications, but a nasal spray, various antibiotics, a cholesterol medication, nausea medication, a variety of medications.
And the medications on the right of it talks about what effects they have on her.
The reported side effect or allergy. Yes.
Like weight gain, shortness of breath. correct?
Yes. Yes.
Hearing.
Yes.
Salt weeping from all orifices and decreased.
Yes, per the records.
What's that?
I am not sure.
Again, she complains about her eyes.
Yes.
She's ENMT. What is that?
Ear, nose, mouth, throat system.
It says tinnitus.
Correct. Yes.
What's that?
Ringing in the ears.
Talks about her psych, correct, being positive,
Yes.
anxiety, insomnia.
Yes.
Still having problems sleeping.
Yes. Per the records.
Back pain, joint pain,
Yes.
and positive for easy bruising.
Yes.
On the physical exam, it talks about psychiatric, I believe. It talks about pain. Patient appears anxious.
Yes.
But it talks about at the top of the constitutional patient is obese.
Yes.
And you have an assessment with her on this visit, correct?
Yes.
And what's your assessment on March 14th, 2018?
Here today, March 14th, 2018, for follow-up office visit. She tried the baclofen for her muscle spasms, but she broke out into a rash on her abdomen, so had to stop this. She established with a new primary care provider who she likes and who refilled her nighttime alprazolam. I'm not sure if it goes on. That's all I see on my screen.
I'm sorry.
Thank you. When asked about non-medication pain relief modalities to try, patient reports that she does daily exercises with the bands that she got from PT.
It talks about risk. Is this risk factor?
Risk factors, yes.
What do you put down for risk factor?
Risk factors can be any concurrent illness or disease that could put a patient at risk for other medical issues.
And what do you list there?
Anxiety, current cigarette smoker, obesity, hyperlipidemia, mild COPD, asthma, hypothyroidism, GERD, gastric reflux disease, hypertension, and restless leg syndrome.
And here again, you formulate a plan, correct?
Yes. To summarize, discontinue the baclofen due to abdominal blisters and, quote, salt in mouth, and offered a retrial of physical therapy, offered pain psychologist, continue non-medication modalities such as swimming, heat, ice, offered nutrition services, but patient declined, and then follow up in 2 months or as needed.
She said, or apparently your plan said would avoid using opioids?
Correct, yes, would avoid using opioids in this patient, for as she is currently taking a benzodiazepine and had alcohol in her last urine drug screen despite her reported rare social drinking.
Towards the bottom of that, it says did you read this part too?
Yes, offered a referral to a pain psychologist.
Had you made that offer before?
I believe so, per the records, yes.
And she refused?
I believe she declined, per the records, yes.
Again, in February of 2017 or 2018, she stopped taking the cyclobenzaprine, correct?
I'm gonna object to ask and answered at this point. We've really combed through these. Overall.
I believe at that point, she has stopped taking the cyclobenzaprine.
And in March, again, as we just indicated, she stopped taking baclofen.
Per the records, yes.
Now, Ms. Trump, in October 3rd of 2018, you probably heard that Ms. Hernan passed, correct?
Yes.
You were notified by somebody that she passed away, correct?
I am not sure.
But in this case, samples of Ms. Hernan's blood and urine and liver and things were taken from her to examine to see what kind of substance, if any, she had in her system.
Yes.
And it was reported that she had cyclobenzaprine in her system.
Yes.
And it was reported she also had baclofen in her system.
Yes.
But she had stopped taking them at the beginning of the year, correct?
Per the records. Yes, my records.
Would there be some concern to you that she has taken cyclobenzaprine again?
There would be concern, yes.
Would there be concern to you that she also took baclofen again?
Yes, there would be concern.
Would it be even more concerning that she took them both?
Yes, there would be concern.
And why is that?
Per the records, it was discussed in her patient report. They were discontinued because they had given her side effects.
No further questions, Judge.
Very briefly, Judge. Ms. Trump, the records that you were just shown, it's fair to say that the most recent in time was the March 14th of 2018 visit. Is that true?
Yes.
And so if the patient's data last time that you saw her and her death per these records, right?
Yes.
Okay. And would it be fair to say that any patient that goes to advanced pain management is trying to get some help, some pain relief?
Yes.
Okay. The records that you went through, would it be fair to say that Ms. Hernan appeared to be very capable of self-reporting symptoms she didn't like?
Yes.
For different medications?
Yes.
Like a rash on her abdomen.
That is patient reported, yes.
Okay, and she reported increased salt in her mouth, right?
What was reported to me, yes.
And weight gain is listed in those records.
Yes.
The records don't have any indication that Ms. Hernan ever told you, I can't swallow these pills. My throat won't let me swallow these. I have to crush them all up.
Not per the records.
Okay. You were asked about the plan at the point in time when you determined to remove the hydrocodone. Do you remember that discussion?
Yes.
And do you also recall that those records actually indicate that Ms. Hernan said that between the two, alprazolam and hydrocodone, the alprazolam was more important to her?
Yes.
Did that factor into the medication she was removed from?
Yes.
Okay. Did you see when you were going through those records that at the first visit in July of 17, Ms. Hernan reported she wasn't interested in pain medications?
I believe that was a part of the records, yes.
Is that actually repeated again in another visit that Ms. Hernan wasn't interested in pain medications?
I would have to reference the records.
Ms. Trump, if I told you that in excess of 6 different times, there's a negative indication for depression for Ms. Hernan, does that coincide with your memory of those records?
I cannot recall, but if that's what's documented.
Would depression be part of that psych system that's reviewed?
Depression is a part of the psych system.
Okay. In portions of the records, I think you talked a little about bladder and bowel issues. Do you remember that?
Yes.
When you were working at Advanced Pain Management, did they have the ability to run labs, for example, for tetrahydrozoline in someone's blood?
I cannot recall what specifically could be tested for, but we did routine urine drug screening, but I do not know what specifically besides like controlled substances were assessed.
If I told you that tetrahydrozoline is in over-the-counter Visine, would that be a controlled substance likely to be tested for at your office?
Over-the-counter medications are not controlled substances.
Okay, so that would not have been something that was tested in anything, any sample from Ms. Hernan throughout these visits?
To my knowledge, no.
Okay. That's all I have. Thank you.
Any redirect?
Trump, is it, while you were treating Ms. Hernan, she was also being treated by a primary care physician?
Yes.
So if you weren't prescribing medication to her primary care physician was correct?
Yes.
She was receiving medication from you, also her primary care physician, correct?
Yes.
I have no further questions, Judge.
All right, thank you, ma'am. You may step down.
Excuse.
And she may. Thank you for being here.
Could we see what sidebar then on
Yes,
witnesses?
please. You read my mind. Ladies and gentlemen of the jury, this will be an excellent opportunity to take our lunch break just a little bit early. And just given some of the timing with witnesses, we'll pick back up at 1 o'clock. So please remember the admonition. You've heard it many, many times. You may not discuss this case among yourselves. You may not do any research or review any type of news. All rise for the jury, please. Thank you for 6-6. I'm trying not to drop things anymore. You can have a seat when the door closes. The second one, I'll put the sidebar on the record. And just very briefly, the sidebar was just about timing. the next witness for the defense will be available at 1 p.m. So we all agreed to take the lunch break now. Anything either side wants to add to that from the state?
No.
From the defense?
No, thank you.
Anything else we need to go over before we break?
I would just indicate to the court, we do intend to put a rebuttal case on. And so we'll work with the defense to try to get clarification on when that would begin. It involves a witness that's out of state.
Okay, very well. Thank you for letting me know. I know we have two medical experts for the defense. I think we have their pathologist and their toxicologist left to go. And then, of course, I'll need to do a colloquy with Ms. Kurczewski and whether she will testify or not. And so I appreciate the parties working together, and we'll keep this moving along. So thank you. We are in recess.
Okay, well, we have just under 90 minutes. It's such a stupid story, though, about Jessy claiming that some random person at a bar slipping eye drops into her drink. I mean, really? So we're starting to talk about rebuttal witnesses, or rebuttal case. Two more medical experts, or one medical, one toxicologist. Sounds kind of dull. Oh, I'm so ready for the verdict on this. Okay, let's see what's going on with the other trial, the hit and run wife. That one will be breaking at about the same time. So, let me see if we've got anything going. Suppose we could go back and look at the beginning of that case, but let's see what else is on YouTube. I had an appointment come up. I was on the waiting list, and they contacted me saying they had a time slot for next week, and I was going, oh, great. And then I realized that's when the Jim Brenner hearing will be going on, so I'll either be waiting for that or driving back. So let's see. Hmm. Looks like Judge Stephanie Boyd down in Texas is also on a lunch break. Okay, let's look at my playlist. Okay, here I think this is a soft sit case. Let's take a look at that for something a little more amusing. This
Kitchen knife is a Christmas gift. Or
2018 was stopped for a possible suspended license. Once the officer approaches the car, we can see how Pratt has started questioning the officer instead.
How's it going, man? Say that again? Because you have a possible suspended license. You have your license on you. You don't have your driver's license on you.
He's going to be a sovereign citizen. He's got all the hallmarks. He's recording.
Man, I can barely hear you. Officer Stetson work for Pinehurst Police Department. I don't have a business card on me. Yeah, that's my call. That's my call sign.
That's not your name. I need to know who you are. I need a business card.
Huh. No way.
That's who I am right there. Got it? Right there. Again, that's my call sign. It's a nickname.
Oh. One thing on your comment there, Melmac, no one knew about eyedrop toxicity back then. Actually, they did, because there were 2 cases of eye drops being used for murder in I think it was June and July of 2018, and this case was in October. And so it was in the news in some places on that. The first case was a nurse who murdered her husband, who was a millionaire, with eye drops. Then the second one was a paramedic who murdered his wife after he heard about the case of the nurse doing it. And so this was a few months later when Jessy did it. And so if you ask me, Jessy saw headlines about it and went, "Oh, what a brilliant idea." So Okay, back to our sovereign citizen. He's not rolling down the window. He's videoing. He's trying to interrogate the officer like the officer did something wrong. This is definitely a sovereign citizen. So here we go.
Pinehurst Police Department. Yes. Do you have your driver's license on you? Okay. What's your name? Sir, I'm not here to argue it. What's your name?
As Pratt deviates and refuses to provide his name, instead choosing to argue with the officer, a call is made to the supervisor. Seeing as this can easily escalate, he also shows the officer what appears to be a court order regarding his case, where he had previously been in a similar situation, and says exactly what you would expect from one of these people.
What are you reaching for in your bag? 10-4. For a possible suspended license, what's your first name? Okay. I'm not here to argue with you. Yes, you are. What's your first name? What's your first name?
Don't let there be lost. I don't have to identify myself.
Yes, you do. Sir, I'm asking you what your name is. What's your first name?
You know, before I say anything else, I'm gonna let you know anything I say now is under threat, duress, and extortion.
No, this is an investigation. It's an investigatory traffic stop. What's your driver's? What's your name? I'm not going to argue with you. Give me your name. All right. If you prolong this anymore, I'm going to.
I'm not required by law.
You are required by law in the state of North Carolina. You know the little thing you sign when you get a driver's license? It's called implied consent. You know what that is?
I never signed nothing.
Because you don't have a license?
And then on top of that, sir, you threatening me right now.
How am I threatening you?
Because first you said something about if I prolong this any longer, you said something.
It's only going to be worse for you.
No, actually it's not, because I've already had a case like this where I prevailed, and just like this, I have it on camera, just like this.
Uh-huh.
So I'm actually trying to help you.
Okay. Where was your case tried at? In Cumberland County?
And I definitely prevailed.
Or Knoxville?
Definition of ID. I'm not required by law.
Needless to say, that everything this guy is saying is absolutely insane, and he's just trying to evade his responsibilities. The supervisor then did.
So all I've got so far is PJ Pratt.
Open the door.
1225.
Open no door.
Get your driver's license?
No, I don't.
You have a driver's license?
He's saying he doesn't.
Who are you?
You have a driver's license?
Not on me. Who are
Okay,
you?
I need your driver's license or your ID card, please.
Who are you? Who are you? Let me see your business card.
Identification, please.
I'm not required by law to show my identification.
You're going.
Easy way or the hard way?
It's a threat, though, and I got you.
Easy way or the hard way?
Just so you know. I'm getting my
Pull it out.
Easy way or the hard way?
The officer, seeing Pratt still not comply, he warns him that he has two choices, the easy way or the hard way, where he'd be forced to break the glass. But Pratt then does the unexpected.
I don't care.
What's his real name?
ID, break it.
That's also a threat. Sledge.
Give me your license. I saw your license. I already saw the driver's license. Give me the license.
Oh, a paper.
Yeah, the paper license.
He's going to come out of that car.
Yes, he is.
I'm not gonna car.
You're gonna come out. Hand it in. There you go. Out of the car. Again, you're gonna do it the easy way, or the hard way. Got it. Hey, grab my shit.
As stupid as it gets, Pratt provides the officers with his ID and license, only for the officer to confirm that it was suspended. Pratt then has stopped, and this time, the officers wasted no time in playing nice and immediately get to making the arrest. After being handcuffed, surprisingly, his madness continues.
Can I speak to somebody?
Michaels helps turn your ideas into I did it.
Nope. You're gonna sit there and shut up. Buddy, all right? Yep. You good? Yep.
All right, so I'm guessing you ran for a reason. Let's find it.
Yep. Unless he's just being. Say what? Man, you ain't in a position to make any requests right now.
Honestly, I am.
How are you?
You're in the wrong.
You shouldn't have ran. I don't know what you call that then.
While the officers search Pratt's car for any weapons or drugs, Pratt asks to speak to the sheriff, and when the officers don't play into his whims, he screams out for help, claiming it's police brutality.
Okay.
Not only that, he claims that he would soon be let free and get paid for the damages being done to him and his car. A quick run of Pratt's license gives officers information about his background, who seems to have several pending cases against him. Pratt's argument? It's not him.
I already checked your cuffs, man. You're good. Stop squirming.
I'm not moving. But anyway, so I can't get the water.
Harold Edward Pratt Jr. That's not you. That's the driver's license you gave me. And that's what's on your military ID. So how's that not you?
It's you today.
Is it me today?
It is.
First off, that's a salt man name because it's in all caps. But it's me, I mean.
I'm looking right now.
They are not. You're gonna find nothing.
Okay.
Why did I drive off? Because they trying to break my window. My window. Trying out jurisdiction. Village of Pinehurst. I wasn't in Pinehurst or near the village of Pinehurst. That says village of Penn. Probably says P-I-N.
You like being Nicoladas?
No.
I like being charged right now. Stolen goods, resisting public officer, speeding, or and failure to exhibit surrender license. Once again. So you beat that? Oh, why is it still pending? Nah, sorry, bro. You ain't doing it. I promise you. You ain't been in here. You haven't been in Moore County, have you?
Then, as cops find drugs in his car, he starts blaming them for planting evidence on him.
I put it in the jar. Okay. It's all on video too, man.
Despite his cries that he's going to sue the officers, opposite, on March 5th, 2023, an Arizona officer stopped a car that had fake number plates on it. Once confronted, the unidentified man not only denied revealing his identification, which in itself is
Crossroads from Stone Police Department. The reason I stopped you is for it appears you have a fictitious license plate on the back of your vehicle. Do you know anything about that? I'm a sovereign human being. Okay. And I'm an American national. Okay. Do you have your driver's license, insurance, and registration, please? What? No. Do you have any? All right. So just so you know, I've been pulled over a couple times already by state troopers, sheriffs, and this is recognized. Okay. Okay. I don't agree. So okay, well, I'm going to be honest with you. That's actually a misdemeanor crime for you to display a fictitious.
Sorry, we're having a little trouble with StreamYard acting up.
actions, and that he would be dragged out if he didn't step out of his car.
Step out of your car, please. I didn't do anything wrong. Marijuana, I need another unit. Step it up, please. I did not do anything wrong. Pennsylvania versus Mims. This is a Supreme Court case law that says you're required to get out of that car if I ask you. If you do not, get out of your car. Call my lawyer. You can call your lawyer if you want, but as soon as another officer gets here, I'm going to force you out of that car if you don't get out on your own.
Despite having the typical sovereign behavior, the man later revealed himself to be Matthew Tutoroni after the officer warned him that refusal to identify oneself would result in a charge. Nothing but wonder, why would they comply with laws they swear don't exist?
I don't need to be under arrest. I didn't do anything wrong. You're being detained right now. And Pennsylvania versus Mims is the United States Supreme Court case law. You're being detained. Why? Because I told you I'm investigating one crime. Okay. You also said you don't have a driver's license, which is another one. And if you don't provide me a form of identification when I'm investigating you for a crime that is a third crime that I'm investigating you for. You are required by law to provide me your true full legal name if I'm investigating a crime. Oh, this car? If you do not provide me with your true full legal name, you can be arrested for that. Matthew Tutoroni. Okay. Do you have a driver's license or any other form of identification? I am a sovereign being. My name is Matthew Tutoroni. Okay. Again, Arizona Revised Statutes 28-1595 requires you to show me an ID card or driver's license.
Not only is he making the situation worse for himself by saying there's no crime here, but his beliefs have led him to believe he has done nothing wrong when he had in fact committed several crimes. He has had enough.
If you don't get out of your car, Matthew, look at me. Matthew, look at me. If you don't get out, I'm going to force you out. I'm going to charge you with resisting arrest also. So get out, please. Come on. 10 times to get out. There's no reason to act like this. Get out of your car then. All right. There's no reason to act like this. There's no reason to
Get
act
out.
like this. Do not touch me.
Get out.
Do not touch me.
Get out of your car.
Do not touch me. Do not touch me. Please. Please do not touch me.
I've asked you 10 times to get out. Get out on your own then.
What are you doing? Please do not touch me.
Officer Ramirez. Ow! Come on. Get on the ground. No! 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 I didn't do anything, Officer Ramirez!
All right.
Please, I didn't do anything! Get on your stomach. Come on, Officer Ramirez.
Just comply.
Come on.
Just comply for now. All right, just comply for now. Okay. Information. If you wish to file a complaint later, okay, but right now just cooperate. Okay. Okay. Okay.
Very one.
All right. Just listen. All right. I just got here. Okay. But right now, the best thing you can do is just comply. All right. If you want to file a complaint, I will give you that information. All right. I promise. My superiors will overlook everything. Okay. All right. But the adder repeat himself. All right. Like I said. All right. Just stand up. Stand up. All right. Matthew, what are you?
You are? You were detained from the beginning when I told you that.
I know. Just relax. Okay. Right now, you're safe. You are safe. Sovereign plate on there. You did comply with my officer here. Okay. All right. Just relax. All right. You are safe.
Go ahead and take a seat for me, all right?
Just relax, Matthew. Okay.
Just like this. I just want some.
Put your feet in
Please,
for me.
I just want.
We'll get you some water. We'll make you some comfortable. Right now, we got to do what we got to do. All right. Okay. Please comply, Matthew. All right. I'm here. All right. Okay. Just comply with this. All right. We'll make you comfortable here in a minute. All right. Just relax.
Watch your leg, okay?
After being arrested, a quick search of his car was done, revealing a gun.
He's like, they don't teach you this in the academy. Back here. Well, one looks wooden. The other may also be. Yeah, they might. Yeah, they're foam. I'm crazy.
Driving around with weapons in a car that had no registration plate is certainly what a sovereign citizen would do. The charges this man faced are unknown, as he was the one who posted this video without further explanation and a more shocked pause and acting this way just to record the interactions and upload them to the internet. So basically, he pretends to be a sovereign citizen and waste people's time just as a hobby. But more windows being broken due to stupid behavior doesn't end here. Calvin Jones, in April 2016, was traveling with his wife and younger brother in the districts of Downriver, Michigan. Taylor officers stopped Calvin, and here he realized who he was dealing with.
How you doing, sir? How you doing? Happy to tell you once I see who I'm talking to, all right? I need you to let me know, like, what's going on, like, what happened? I'd be, like I said, I'd be happy to tell you once I see information. I'm not giving you my information until you tell me what you pulled me over for. All right, sir. Failure to give me my information is a arrestable offense, okay? So you can either do this the easy way or the hard way, all right? I need to know what you're pulling me over for. I'm going to tell you once I see information, all right? I got information, but I'm not giving you my information until you tell me what you pulling me over for. Here's the deal. Either give me your ID or you go to jail. How about that? Put this on camera, man, because we're not dealing with this. Give me your ID. I need to know why you pulling me over. Give him your ID. Detail 5 radio. I'll be on the stop, entrance to the parks. Can you send me another car? And cooperative accident. Last chance. I need to know why you putting this over. Give him your ID. He's going to tell you. Where's he again? The entrance to the park. From the park. Is my tag expired? Are my lights off? I'd be happy to tell you, sir.
Calvin's wife can be heard in the background telling him to comply and provide the officer with his ID. It's procedure for cops to ask for Eyedrop after they've heard the bad news by taking off or using violence. The police know who they need to get. Calvin then is seen showing clear signs of guilt as he tries to find a way by pretending to know his rights.
You supposed to tell me what's going on, man. Are you a lawyer, sir? Hey, I'm representing myself right now. Okay. Because to be honest with you, no, you can't. Sir. I don't answer any questions. Okay. Well, it's going to turn out very poor. I'm going to tell you what the deal is. You're probably suspended. So you don't want to give me your license. I don't have to give you my information. Okay. And that ain't right because I just renewed my tags in October 2015. Okay. So my tags is good. So am I free to go? No, you're not free to go. This is an investigatory stop, all right?
And after more nonsense discussion, things turned south. I don't know about you, but if I see a cop putting on gloves, something is about to go down.
All right, here's the deal. Hey, put this on camera. Put this on camera. You gotta let me know what's going on, man. You're not going. You're going to jail. Is what's going on? For what? For what? You ain't. What charges? On what charges? Wow. Get out of the car now. Get out of the car, man. Get out of the car. Get out of the car. Get out of the car. Let me get out of the car. Get out. Get out of the car. You ain't getting out of the fucking car. Get out of the car now. Get out of the car. On the ground. Put your hands behind your back.
After a long struggle, Calvin was finally put in handcuffs and arrested. Then the same situation goes for his wife.
Put your hands on the car. I'm sorry. Put your hands on the car. Don't touch my phone. Get it out of your hand. Put your hand on the car. Grab my phone. Police brutality. Police brutality. Police brutality. I ain't even doing that. You listen to what we're saying. Well, you're going to jail too. Real simple. Alright, what's up? Alright, I'm gonna roll you over, right? Listen, roll you over. Get your knees, stand up. Get your knees up. Ready, look up. 1, 2, 3, get up. Come on, right back here.
Despite the woman calling this police brutality, it is uncertain if that's how this ordeal can be tagged. Calvin was lawfully stopped for running a stop sign, and he refused to provide his ID, though the officer doing the stop didn't tell him why he was being pulled over, as it is the norm. As of now, after a thorough investigation, the charges against him have been dropped. If you enjoyed this video, watch this one, and don't forget to subscribe. Bye.
Okay. Let's see. We still have some while to go before we have. Oops. Let's see. Let's go back to the. Oh, yeah, there was an arrest. I saw some. Oh, well, they got my hopes up when they went from the flagpole to the shot of the courtroom, but seems like we're still just doing things. But hopefully they're all ready to go. So I think they said first would be the pathologist. I mean, I don't think that they're going to say that it's anything other than the tetrahydrozoline, but they might say that some of the other drugs were a factor as well. But as the medical examiner on the case said, the stomach, the pills in the stomach haven't been absorbed into the system yet. So I don't know. The poll on the guilt at the time things the case closed for the state, it was around 98. It seems to be about I'm more concerned about a hung jury than not guilty. Yeah, it just seems like the tab is not loading very fast, so let's see. They've got 94%, 5% hung. Okay. It looks like people, friends of Jessy, or not Jessy, Lynn's have come in. I don't remember well enough what Jesse's mother looked like to see if in the background. Oh, come on. Well, let me take a look over here at the
deserve that. The public deserves that. Everyone deserves that. I mean, that's my biggest issue with the case is just the secrecy. And I'm not talking about confidential, highly inflammatory crime scene photos. I'm talking about just the docket of things that are being filed, motions that have been filed that have never been set for hearing dates. There's motions in limine regarding the ballistics that were filed. There's the Franks hearing. It was
Right. What
filed.
about the
Motion
Franks
surprise.
hearing? Yeah.
I don't know.
That's just
None-
up in
none of it.
limbo, isn't it? Huh, Bob?
None
Yeah.
of it. Cases like this, it's a huge case. There's a lot of moving parts, but I don't know. We'll see how it plays out.
Right. No, you're making great points, Bob. Thank you for that. Shay Hughes, want to go back to you on an important point that we were unpacking a bit last night on the program, and I think it's really important enough to reiterate with respect to this case. I think a lot of people are under the misunderstanding that Andrew Baldwin and Brad Rosie were privately retained. They were not. They were publicly appointed to the case. And so it raises a really interesting legal question with Richard Allen's right to counsel. Does he have the right to who he wants? Now, with publicly appointed attorneys, you don't get to pick and choose. But I'm wondering now that those attorneys have said, we do it for free, pro bono, for free, not a dime. Are we asking his representation? His choice in matter, in your opinion, legally, Shay?
Well, I think it certainly does change the dynamics of this case. You know, there's authority from the Supreme Court that if you somehow deprive a defendant's right to choose, that in and of itself is a Sixth Amendment violation. It does not matter the effectiveness of your counsel thereafter. The moment a court deprives a defendant of their right to choose counsel is a violation in it and of itself. You know, I don't think it matters at all that they entered an appearance pro bono. I think if anything, that strengthens the argument. So I have some serious concerns about the court rejecting the appearances of both Rosie and Baldwin thereafter.
Shay Hughes, thank you for that. Here's what we're going to do. We're all going to stay put. We've got so much more we have to unpack with this case. Got to hit a break as we're at the bottom of the hour. When we come back, we'll answer the question, do investigators help on social media? Let us know. Coming up next, we are zeroing in on the evidence in the case and what prosecutors say links Richard Allen to the crimes. A Wisconsin woman accused of killing her friend with eye drops.
And then defrauding her for over $250,000.
The state believes this defendant has evidenced her capacity to take advantage of at-risk individuals.
Was the victim trying to commit suicide?
Or was she murdered for money?
The Eyedrop's murder trial. Live coverage weekday mornings at 8, 7 Central on Court TV.
Sure.
That video taken by victim Libby German just minutes before she and her best friend Abby Williams were brutally killed. And it would become a key piece of evidence now for investigators in this case. It took 5 years, but they say that the man in the video is Richard Allen. So we want to look at some of the evidence to answer the question, did police get this right? Is it Richard Allen? Let's take a look at their affidavit of probable cause. Remember, this was released after he was arrested. It wasn't released right away. Part of it says, quote, there was also a .40 caliber unspent round less than 2 feet away from victim number 2's body, between victim and victim 2's bodies. And that round was unspent and had extraction marks on it. The laboratory determined the unspent round located within 2 feet of victim 2's body had been cycled through Richard M. Allen's Sig Sauer Model P226. Investigators believe Richard M. Allen was the male depicted in victim 2's video, saying guys down the hill. They believe Richard Allen was carrying his Sig Sauer Model P226 on that day due to the cycled round matching that firearm and being located within feet of victim 2's body. They further believe he was carrying the Sig Sauer Model P226 from the audio from victim 2's video, in which investigators believe they hear the sound of a gun being cycled and one of the victims saying the word gun. Still here with me, investigative journalist Susan Hendricks, who wrote the book called Down the Hill. Murder Sheet podcast co-hosts Anya Kane and Kevin Greenlee, criminal defense attorney Bob Mata, and deputy public defender for Tippecanoe County, Indiana, Shay Hughes. Oh boy. Okay. Did police get the right guy? That is really the million-dollar question. I know opinions are split on this with different people I've been talking to. You, very curious to hear what all of you think about this, as you are all very well read in on the facts of this case. Susan Hendricks, my friend, let me start with you, please.
So defense attorneys, as you know, their job is to go in and defend their client. That's absolutely their right, whether they think he's innocent or guilty. But going in, I feel like there's been a lot of distractions. It's almost look here, not over here. Look here. We see that with the latest 21-page filing, I believe. It's almost trying it as we're talking about it. And earlier, we were showing a picture of the bridge, and it's been refurbished up to a certain point. And when I was there the first time in 2019, in February, it's vastly different. It shows how much time has gone on, right? For the families, that looks so much different than what I saw. So think about for the families. My daughter's now 14. As time goes on and they mark these milestones, she should have been graduating high school. She should have been in college. Kelsey had a baby, a daughter. She should be here. All of these milestones. So then when it feels like the egos of the defense attorney, to me, it feels like that. The egos that are involved in this, and we should do this and we should do that. And that absolutely Richard Allen has rights, absolutely right to a fair trial, absolutely innocent until proven guilty. As we all know, the prosecutor mentioned, even in that October 31st press conference, there could be other quote unquote actors. I'm not saying that the investigation should stop. I'm just saying that it feels very frustrating to people who are on the outside looking in. It feels very frustrating, and especially for family members saying, what about their rights? Because they don't know the minutia when you get down to it. And I'm looking forward to the decisions being made. I don't know the right decisions. The Supreme Court will make those decisions, and I hope it happens fast, and I hope he gets a fair trial.
Sure. But do you think he's the right guy?
I don't know.
Not sure. Okay. Fair enough. Bob Mata, do you think they've got the right guy?
I lean innocent on this.
Tell us why.
We've all read the probable cause affidavit. I thought when that came out long before it was very thin, meaning that I didn't think they had much evidence. At this point, we know all of the it's not good, and that's just factual. I mean, they can get it into evidence. I don't think that they'll be able to have it kept out of evidence, but it'll go to the weight of that evidence. They're not going to within a reasonable degree of science came out of Richard Allen's 40 caliber weapon. You know, when I just look at it on its face, only knowing what we know now, I believe that he's innocent. But, you know, beyond that, what in the one area that I disagree with Susan, I don't think this is about ego in terms of the attorneys. I honestly believe that they truly believe that their client is innocent, that they have exculpatory evidence. I think that this is what it looks like when two defense attorneys are doing everything in their power to make sure that an innocent man doesn't get convicted. And until you've been in the defense attorney's seat, where you have a man that you believe with all your heart and the evidence is supporting that he is innocent, you can't really know, because it's the heaviest burden you can have to be laid on your shoulders.
Sure.
So that's the way I feel about it. And like just the fact that they put out that memo, love it or hate it, it shows me one thing, that these guys are fighting to the death on making sure that an innocent man, in their estimation, is not going to get.
Right. You know, another big piece of evidence that the state has against him is his admissions. He admitted to being on the trail that day when the girls were killed at the same time. And then he's off the trail at the time police estimate these girls are being brutally murdered in the woods. Now, the officer who interviewed Richard Allen back in 2017 wrote that Allen was on the trail that day between 1:30 and 3:30 p.m. and the clothing he told investigators he was wearing matches the clothing in the video that Libby recorded. We see that blue Carhartt jacket, the jeans. Finally, the document says that a witness observed a man walking on the west on the north side of the 300 North, away from the Monon High Bridge. And the witness advised that the male subject was wearing that blue colored jacket, blue jeans, and that he was muddy and bloody. She further stated he looked like he had gotten into a fight. Another very damaging piece of evidence, isn't it? Kevin Greenlee and Anya Kane, want to go to you next, please. Do you think police have the right guy? Why or why not? Kevin, to you first, please.
First of all, I think you're absolutely right when you mentioned that a lot of the evidence against Richard Allen comes from Richard Allen himself. He places himself at the crime scene. And of course, he's also made some incriminating statements to his mother and his wife while he is in prison.
Mm-hmm.
I think, though, that as frustrating as it may be to say, we don't have every piece of information yet. And so I believe that I'm going to just let the process play itself out. Let's see what gets presented in court. Let's see what the defense has to say to the prosecution's evidence. And I think only then will it be possible to come to an informed decision.
Kevin, what don't you think we have right now? I'm curious.
Well, for one thing, Richard Allen, as I mentioned, he's said to have made some incriminating statements to his wife and his mother. I'm curious, what exactly did he say? Did he give out details that would really conclusively prove he was there? Was it just raving or incoherent? I'd be curious. I think most people don't make incriminating statements to their wife and mother. So I'd be curious, does the defense have some sort of explanation for why he did that? So that's just one example of the things I really think we need to get a better idea before we can really properly evaluate.
Fair enough. You all have been a wonderful panel tonight. And every time we have you on Court TV, we have to leave it there for now. I know we're going to be picking up this discussion as the days and weeks roll on. Big thank you to Susan Hendricks, Shay Hughes, Bob Mata, Anya Kane, and Kevin Greenlee for being on our power panel tonight. We'll see you soon.
Okay, there has to be something going on that's causing some delay. I'm guessing that there's some issue with a juror getting back to the courthouse after lunch, because this is just very strange to have such a a long delay here. So, let's see. Looks like we're running like a couple seconds behind. Let me refresh the tab. And Aowen is weighing in. They stood up like the judge has come in. Or was that my imagination? You see that the detective, he was on the stand for, what, 3 full days? Is in the courtroom. I noticed that defense counsel was over talking to him briefly. Okay, I'm going to look at the app formerly known as Twitter and see if there's anything on there on Jessy. Oop, I didn't spell Kurczewski right. Let's see. Oh, I really messed up the spelling. Okay, let's. Oh my, they're saying. Oh, wait. No, yeah, they're. Oh, 28 minutes late in getting back? Wow. That's shocking. After the pathologist and toxicologist testify, then we're going to find out if Jessy is going to testify. I would guess she's not going to, but you never know. Was during the interrogation, I can't see putting her on the stand. So, oh yeah, there's somebody who's in Great Britain. It says, when we Muslims uprise in Britain, we will come door to door checking everyone's Islamic status. You will be given a choice to convert to Islam or be eliminated. It's as simple as that. I think the forced conversion is not not gonna mean much. Let's see how things are going in let me check this. We've got Judge Kristen D. Simmons courtroom.
What I'm saying is that it's not proper for the legal services to be giving you our court email to send evidence.
Oh,
That's what I was saying.
Oh,
But you wouldn't have known that. Okay, you can proceed with your case, ma'am.
okay. I haven't received 22. So we're going on a year. And then she sent a check.
I would have kicked them out already.
$850, and then she stopped payment on the check. But anyway,
When did she send that check?
It's February 23rd of 2023. And she stopped payment on it. So I don't understand how somebody want to live in a house if it's unfit. Why would you pay rent and then stop paying and then still live in the house?
Okay, and so you have not received any rent, although you did file for termination of tenancy, correct?
Yes.
Not non-payment of rent, okay. You just want possession of your property, whether she pays the rent or not, correct?
Correct.
Okay, and what you can make your defense, ma'am. Why do you believe that you should not have to be removed from the property? You can withhold possession of a property and then you don't have to pay your rent.
I didn't. I paid my rent, and where it stopped payment that's 90 days after she did not cash the check. They stopped the
Your
payment.
ringer on, ma'am. You need to turn it down. Turn the ringers off.
They stopped the payment, not me. She didn't cash the check, and that's for February. But where's the one that for December and January?
So your position is that you paid your rent every month?
I did pay my rent.
Do you have proof of that?
Yes, I have. So after she said that she didn't receive the those two payments, I did stop paying them, because how are you not receiving my rent? Like, this is the way I've been paying my rent all the time, and I've been living here 5 years. So.
It's all the same.
Yeah. Sorry.
Okay, I have here what appears to be a check for $850 to Joy Monroe. February 23rd.
And then there should be another one before that. It's 1650.
December 23rd, okay, for $850. And then I do see another one. This is December 28th for $1650. How much is your rent each month?
$800. But I had a $50 late fee. But that was the 1650 was for December and January.
So December and January, and you paid your November rent, is what you're saying?
Yeah, before.
Okay, so December, you paid your December rent, you paid your position that you paid your December, January, and February.
Correct.
And a late fee for December?
Yeah, for December, yeah.
And what happened with the other months?
The other months I didn't pay because she told me that she didn't receive that money, so I didn't pay her.
So you're saying that since February, you've not sent any money?
No.
Where did you put your money in escrow?
No, I have it in my bank account. I haven't.
You have proof that you put it in your bank account?
I don't have my bank statement, but I can get it.
Proof, and that's for every month from February till now?
Yeah, pretty much.
That's not pretty much, it's just to know. You have $800. So this is going to be a late fee for each month from the time that you last paid, which was February 2023 to now, which is November. You have that in your bank account?
Not until November, I don't. No.
Okay. You did not receive the 1650 check?
I did not. And when she sent payment, that last payment I did receive was like 1,600, it was like 1,000 something. The reason why that check was so big because she was like 3 months late. So she found some kind of organization to pay her rent. And then I was saying your rent is due in December. And then I had to text her and call her, and she was like, it's in the mail. I haven't received payments, like I said, since 12/1/2022. And it's almost a year, so.
Okay, and what you have here, well, I see where case credit union cut a check. And it says on December 28th, 2022, payable to you for the amount of $1,650. Did anybody trace the check? And she said she didn't receive it. Did you have it traced?
I did, yeah.
And what did the bank say?
They said after 90 days, if she don't cash it, then they'll put it back in my account. If they don't find it,
so they put it back in your account?
She didn't cash it. Yeah.
Okay, so why didn't you get her money after they put it back in your account?
Oh, he wasn't saying nothing to me, so I don't know.
Were you still staying in her house?
Yeah.
Okay, what is the habitability issues that you are like?
Oh, there's a lot. My house is a fire hazard. The house is a fire, it's just a lot. It's not.
It's a fire hazard?
It is.
Why, you need to tell me what it is.
My city inspection came and they said that because my doors don't open and we can't get out the doors, we can only open the doors.
Which doors?
The bedroom doors.
The bedroom doors don't open?
No.
Why is that? What do you mean they don't open? You like stuck in the bedroom? I don't get it. Are they, so do you keep them closed all the time?
No, you can't keep them closed because the kids can't get out. If you keep the doors closed, they can't get out.
You keep the bedroom doors open?
Mhm.
Yes?
Yeah.
Okay. And you notified her that the doors were not in proper working order?
Yes, they did.
Who's they?
The city.
Well, that's hearsay. Do you have evidence that they notified her of that?
Yes, it's in my email.
Which email?
The one from the city of Atlanta.
You said, I have about 7. So you're gonna have to tell me where I'm going.
All right. Title 4414 Barclay PDF.
34. Okay, so I see here, code enforcement from 2018.
Oh, no, that's not the correct one.
I see one, failure to comply from 2020.
Yeah, that's it.
Failure to comply letter 2022. You have a valid rental certificate?
No, I don't.
Ma'am?
I do, yes.
Where is it?
Oh, I don't have it. It's still a rental property.
No, I'm
Yeah,
asking, was it
paid that.
valid? Because this tells me that in March of 2022, you received a failure to comply letter. I don't have anything that showed me that you brought it into compliance. Do you have something to show that you brought it into compliance?
Oh, no. I worked it out. I mean, we did all the paperwork is done for Barclay. I called them and told them, because it's due for inspection now, but I told them the situation at the house is in court. And they said, right now, we're gonna hold off until I get this situated. And then
We're gonna hold off on what?
Having the house inspection again, because right now it's not really a rental property.
Oh, that's because you don't
But
have
the-
a valid rental certificate, correct?
Yeah, I paid the fee to have the.
When did your rental certificate expire?
I don't have that with me.
So you don't know if you have a valid rental certificate?
I can get one, but I don't have it with me.
Well, that's not what I asked you. Do you currently possess a valid rental certificate, or was it either expired or revoked due to the condition of the property? Because I can verify this.
Okay.
So
I believe the
I want you to
house
answer, no, not what you should know, because you're the landlord, you're collecting rent. So I want you to tell me in court if you have a valid rental certificate.
I do. I don't have it with me though.
Okay, so you do, and so the January 9, 2022, I'm sorry, March 9, 2022 failure to comply letter that states that you're in violation of the Lansing Housing Code, for failing to comply with the recent housing code correction notice, meaning they'd already sent you something, you failed to comply. You brought that up to code?
Yes, I did.
It says, please sign and
I think it was
return.
out of the furnace or something like that, but I did, yes.
Please sign and return or call for reinspection. And so you would have been re-inspected since, so your compliance date then was April of 2022. It's been over a year. So you should have had an inspection between now and then, correct?
All the inspection stuff is, yes.
When was your last inspection?
I'm due for one now.
When was your last inspection?
I don't have the correct date. I can't make up a date. It's like every 2 years, but I do not have the date.
Okay. Did you have an inspection in this year?
No, it's due this year.
Did you have an inspection last year?
No, 2 years ago.
Then
It's
you
like
don't have
every
a
2
valid
years.
certificate, because if once you get a failure to comply, you have to be re-inspected because they told, and you were supposed to call over a year ago.
I did that.
For them to
I
re-inspect,
took care
don't
of that.
talk over me. I don't know why people think it's okay to talk while I'm talking.
I took care of it though.
I want to see your certificate.
I don't have it with me.
You can book out a seat. I'll call the case back in a moment. Both of you can
Oh,
have
okay.
I think he's on.
Okay, apparently a juror got sick over the lunch hour. And so they're talking about dismissing that juror and putting somebody in their place. So that seems to be what the situation is. Yeah, I thought it must be juror related because all the legal teams are present in the courtroom. So I'm going to continue to look and see if I can find anything. Okay, well, at the rate things are going, maybe they just send them home for the day. Let's see, it's going on 2 there in Wisconsin. Um, oh, I heard something. It's very strange. Okay, I think that woman behind Jessy might be her mother. There's one other lady. I can't remember. It's been so long since we saw the police interview with Jessy and her mother yucking it up that I can't remember what she looks like at this point. But let me see what else I can find. Because they seem to have concluded the hearing that was in progress over in Judge Kristen Simmons' courtroom. Eowyn is weighing in again. Let's see, we could go to, I know taking care of Maya, the jury is deliberating, and apparently the jury asked something, but they're not entitled to it. So let's take a look at that while we're waiting.
Claritin provides powerful allergy relief. Plus, it won't make you drowsy like Zyrtec can.
Well, got another note from the jury. Says, y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today. And it was said that we'd have all this at deliberation. Well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday. Here's the verdict form, or the verdict form, the note form, if you all want to come up and examine it.
Okay. What about can we
get the transcription of Ms. Kirby overnight and then read her testimony?
Well, I mean, you all have hired a private court reporter, and if you wish to pay for a court reporter to do something, that's between you and the court reporter. That being said, what is actually in evidence on this issue?
So testimony, I believe, and we moved, and I think we marked for identification, but I don't know that we moved in or could move in her report. I tried to get her report in. Usually the economist comes in, but I don't think I was allowed for that to go in.
So the report's not in evidence?
I don't think so. We did move it.
It is what it is at this point. So what are we saying?
Well, I think the thing to do is let them know that we'll try to get her testimony transcribed overnight and then bring it in tomorrow morning. Hopefully our court reporter can give us an official transcript to be able to read to them, and that'll give them the numbers. Unless somebody wants to agree to let them see the report.
Well, what is the defense's position on what to do?
There could be a readback, Your Honor, of the testimony. I'm exceedingly, I haven't looked at that report lately. I'm exceedingly reluctant to agree to have a forensically created report put in evidence. There are several bases upon which we objected to it and upon which the court excluded it. And I'm reluctant to revisit that. I'm frankly kind of surprised with this jury, with the note taking that went on at the tenor of the note, because I would have thought that they jotted most of this down. But I'm very reluctant, I suppose, to say anything other than the jury has heard the evidence and is expected to recall that evidence and trust its collective wisdom, or to read back the testimony.
The jury didn't actually ask for a readback.
We offer that as an option nonetheless to resolve their apparent dilemma.
I'm sorry.
Mr. Anderson is asking if we should offer a
picked up and go home. I've excused her. I did talk to her and let her know she cannot talk about this case until it comes to a final conclusion. I also told her that if anyone were to reach out to her from either side, I know you wouldn't, but that's not to say people couldn't try to do things, that would be out of bounds, and she should let me know through the jury coordinator's office or the civilian bailiffs, at least until we have final verdicts in this case, or the case otherwise comes to a conclusion. I told her she is not precluded from watching. Should she want, she just may not discuss this case with anyone until all of the jurors have been released from their responsibility. And I'm letting the jury bailiffs let the other jurors know. And once we get everything set in here with the exhibit that the parties were working on, Madam Clerk, have you been able to do the necessary redactions? Have you seen them yet? Or are we just going to have a new report?
So Angela at my office, with our help, just in the last half an hour, is putting together, she's making the changes.
All right.
And so that's going to be emailed to everybody as soon as she makes sure the spacing is right.
And that will be which reports?
And I thought that I would ask her to, I hope she remembers to do that. Oh, here we go. I asked her to label it 545A. And that's this report of Henry Speller.
Okay, so that's Mr. Spiller's report, but what about the reference in Dr. Thomas's report to, which would be page 6, second paragraph?
Well, I was just working on the Mr. Spiller's report. We didn't, Attorney Nicolai and I didn't discuss Dr. Thomas, or at least I didn't do that. So you want me to, obviously she has to take that Henry Spiller paragraph out.
I don't know if it needs, the way that it is, I would not want shown to the jury. If it's something she relied upon, then we'll have to address that. I don't know if there's another way. It's not my report, but that would be an issue for publication based upon my rulings at the Daubert hearing on December 9th. And I believe she's your next witness.
She's my next witness. So
And she's in the courtroom, so I think that's helpful for her to be able to hear that.
Right.
And the clarifications, and just for the record, so that it's clear, it's 2:00. We've been in the courtroom since 1:00, but some issues came up related to juror number 1, and then related to the court's rulings at the Daubert hearing, Dr. Thomas's report referencing Dr. Spiller, and then Mr. Spiller. I don't believe he's a PhD, if I recall.
Right. You're correct.
Mr. Spiller, and his report, just given the rulings the court made in December of last year, specifically related to the limitations this court placed on his testimony regarding cause and manner of death, because he's a toxicologist, and otherwise from the court's perspective did not have, even under the Hogan decision, the requisite experience to opine on cause and manner of death. It also went to his opinions about tetrahydrozoline and whether it can be fatal. Now, I indicated as a toxicologist, he certainly could testify as to the effects on the human body, that he could testify that his review of the literature, he has not come across a death attributed to tetrahydrozoline poisoning, but that he could not go so far as to say it cannot cause death. I'm paraphrasing. I had an opportunity to review at least my decision portion of the December 9, 2022 transcript. And I know the parties were working on either redactions, or it sounds like some modifications to the report in lieu of redactions, because it's anticipated those will be before the jury. I put a lot on the record just now, but anything the state would want to add to that?
No.
How about the defense?
No, I agree with that. I think, let me talk to Attorney Nicolai for a minute about Dr. Thomas's report.
No problem. We do have the ability. It's a pretty quick, easy fix if it needed to be redacted. I believe we already have the exhibit electronically, and we have a redaction tool and could block that out if need be.
And I think it would be an easy redaction in this particular.
I'm sorry, I didn't hear that last part.
I think it would be an easy redaction, as I
don't know if she has a computer and is able to take it out, but but that's up to you all. We'll go off the record while we complete that, and hopefully we're ready to go shortly.
Sentence that needs to come out. So
actually, yeah, why don't we go off the record, and we'll turn off the audio, and we ask Core TV not to.
Okay, so Welcome back, Cats Gallery. We've been wondering what on earth has been going on because things have been so delayed, and we found out that juror number 1 got sick over the lunch hour. I think from what they said there that the juror can go home and watch, but she can't discuss. That seems rather surprising because what's to stop them from what? Well, I guess they turn off the thing during sidebars, but aren't there times when they're discussing something which isn't in front of the jury? I don't know. Seems rather strange to me. So, let's see. We're taking a look at what the juror question and the Take Care of Maya trial was. So let's go back to that.
So perhaps then, since both sides are okay with me offering a readback, is to tell them all the evidence you have all the exhibits that are in evidence. And if as it relates to witness Kirby, we can ask the court reporter to see if the court reporter is able to type up the testimony. Now, are we going to identify what part of the testimony, or is the entire testimony going to be read? If they ask for it.
I do not believe in and out on that. Mr. Whitney has a different memory. I recall that being exceedingly brief testimony, and I don't think there was much cross at all on it. So I think that if there's an agreement to read it in just as to that specific, fine. If not, reading the whole thing is not going to take that much time. This is not like 2 hours of testimony. This was a pretty basic. She was on Zoom. I wish we had it recorded. We could play it back for them.
Was it recorded?
I don't know. I don't know if you can record Zoom on the court proceeding.
We don't do that.
Okay.
Didn't think so.
Judge, if we're going to read it back, I think we read the whole thing back. And my recollection is similar to Mr. Anderson's. I don't recall this being more than 30 to 40 minutes.
Well, my recollection of the case law on readback is as follows, that if the jury is asking for it, then obviously we can do it. And certainly that's not a problem. Obviously, are we opening the door for them to start asking for readbacks on everything, which of course it takes a lot of time. And, I can tell them I don't know if we're going to be able to get it for you overnight or not, but I'll say it's going to take some indeterminate amount of time to get it back. But unless the jury's request is specific, I don't want to do anything other than read the entirety of the testimony unless the parties jointly agree to some narrower scope. And maybe if you do get the testimony tonight, you can discuss amongst yourselves what
It's certainly reasonable, and once we get it, I think we would then correspond with the defense and ask them, and if they don't, again, I do not believe that it's a particularly onerous amount of time. So what we need to do is find out about the transcript, which I'm fairly sure we can get done overnight with only a half hour worth of testimony, and then provide it to both of us, talk, and then read it back to them tomorrow. I don't have any objection, since they have only identified this one section out of everything in the trial that they need. I would think under the case law, it would be appropriate to at least suggest that rather than an error in an objective fact that should be before them.
Okay. I think we'll go with what I had suggested. I mean, they said they wanted to go until 6:15, so this is probably a good time to stop anyway. I'll still have them come at 8:15 if they are able to do that. I'll give them the option that's a possibility. And maybe I should say, if we're able to do it in the morning, can you tell us specifically what part or parts, or should we just don't give them that option?
I think that we leave that for tomorrow and we see how long the entire thing is. I don't know that we're saving that much time if it's 25 minutes and 10 minutes of it, or, but
And
I'm open to anything. that we're-
who's going to read? Who's going to read it?
Who's going to read it?
Maybe we can get some wigs.
I'm going to get Ms. Lawrence in here. She looks like very economist-like. We can dress her up.
We can share the reading, Judge. We'll work that out.
Perhaps maybe one person from each team. I just don't want to get into a who's reading, and I don't want there to be, if we're going to go down this route, I don't want there to be any, oh, your inflection was different or anything like that.
I'll be happy to read it, Judge. I'll be happy to participate in reading it, however they want to do it.
I think both parties agree we have bigger fish to fry than who's wearing the right wig.
Okay.
And heaven knows I need one.
That's what we're doing. Let's go ahead and bring in the jury, have them seal up their. Yes.
Okay, that doesn't sound like there are any. Let's take a look and see if there's anything new. I remember seeing earlier, it sounded like somebody was being arraigned in court, but I couldn't find that one when I looked again. Let's look at Judge Stephanie Boyd down in Texas. Not sure. I'm not hearing any volume over there, so. Let's take a look and see. Okay, let's check in on the hit and run homicide trial.
I know your mind's spinning. I understand that it's gonna be.
It is. No.
Okay. All right. Let me. I really want to try to be able to help you put together your time frame a little bit better, or at least put times to it. Not, I mean, your statement's well written and everything, but I think if we could add some times when things may have happened, and the phone
Can
might.
they give us the phone just to use until?
The phone might help us do that.
Right.
They're working on that aspect of it. I don't know where they are, but we can. The camera system will probably help so that.
Oh, for
we can
sure.
figure, yeah, that'll give us, details that we can backtrack on.
Right.
Yeah. So let me just do some more checking.
I just hope the cameras are on. I mean, I don't know if they were or not. I have no idea.
Okay.
I'm assuming they were if I had to turn the cameras off to come home.
Yeah. And that's something that sounds like Mark typically would have done. Lock the door. You say you locks the door and
We double lock the door. all
double
the
lock
time.
the door and turn the cameras on when you're not there. I think that's
Well,
something
when
that's
he's
kinda-
in the cities, I have the cameras on all the time.
Sure.
Because it just makes me feel safe.
Absolutely. That's what they're there for.
Right. So when he's home, we just don't have mine that often. We turn them off. Unless if we go somewhere. So if we went somewhere, then likely we should have turned it on.
And when he's home, would he be the one that would probably turn it on or turn it off? Or
We both do.
We both do.
Yeah, it's a one little button, so it's so
It's
simple.
pretty simple.
Right
camera
off, right off of our camera or phone.
And so there's a camera when we're standing on the first driveway, and you're looking at the house. There's a camera that sits there. The shed,
Man cave.
man cave. Is there one? You see where the truck was, like the door that I walked into.
Oh, the spinning wheel of death. Oh, you never feel.
Your house with there's a
There
camera
we go.
that's facing
On the house, not on the little porch, but it's on the house.
on the side of the
So you
house.
can see the man cave and the garage.
Okay.
And then the last one we have, we put by the hot tub, so we can see if anybody ever tries to go into the barn.
And I didn't see the hot tub. The hot tub's on the back side of the man
By the
cave.
pool.
Okay, I didn't get down that far that there's a pool. So that's on the back side of where that is. Okay. And then there's,
So when you look at, you can see it shows you the three cameras. So if you look at the phone, it will show you all three cameras. You can go live,
So
you can go
first driveway, back door facing the man shed, and then over the top of the hot tub pool area.
looking at the barn. I gotta clean the little
Okay.
barn.
So it'd be kind of angled. Okay, I understand that. Okay. All right, I'm gonna go check to see if they have any luck on that, and then I'll be right back. All right. Trying to think if there's anything. My mind starts when I start asking questions. Sometimes I just want to see, make sure there's nothing that I didn't ask you that is pertinent. We're back. You good? You need anything? Okay.
my God.
Scott, is that Mark's brother? He's here. I'm gonna go, I'll let Kimmy come in and hang out with you. Is that okay? And I'll just talk to him, explain what we know and don't know at this point. All right. I'll bring her in.
You're my baby.
Scott and Todd are here. Is that your other brother?
His other brother.
Okay, I'm gonna go talk to them. So, do you need anything? Okay. Be right back.
A juror got sick over lunch, and they were talking about sending her home or dismissing her. It sounded like they were saying she could go home and watch the trial, which seems rather surprising because they're watching online. They don't get to see the evidence most of the time. So we're kind of wait and see what happens in Judge Dorow's court. And meanwhile, we are looking at day 3 of the hit and run homicide. This woman apparently ran her husband down after they had a fight, and she left her husband to die. And I guess she said she didn't realize she had hit him. She declined to give him CPR when she found his body, saying he was frozen to the ground. She's looking pretty stressed here in the interrogation video, where they're just kind of observing what her demeanor is. So, yeah, some people are wondering, did Jesse's mom spike juror number 1's drink with some Visine over the lunch hour? Oh, no, she better not sing Silent Night or stand on her head and do yoga. Yeah, I'd be stressed out.
Discover imagination with Tony's.
Ultra Healing Fragrance Free. Same 48-hour healing hydration, just without the fragrance. The feel-good feeling of Jergens.
More commercials. I thought at first that she was an old lady, but I see now it's a
Investigator Linefeller, before we move on from the video, can you please let us know? I guess my question is this the end of this video in terms of time, physical time?
No, it is not.
Can you indicate about how much time you think is left?
14 minutes, 20 seconds, it looks like by the timestamp.
We've paused the video. Is there anything from your memory of, at this point moving forward, that happens in the last bit of this video that you would like to share?
Nothing of significance.
And that was exhibit number
76.
What number, Your Honor?
76.
I asked that exhibit 76 be removed from the screen.
Yeah.
Oh, I had asked that it be removed from the screen.
Oh, okay.
Your Honor, I hate to ask this, but I could use a bathroom break.
Okay. You don't have to hate to ask the folks how some might need it. All right, why don't we take a 10 to 15 minute break as soon as everybody's ready.
Thank you.
okay. That figures. Now we're on getting the afternoon break. And we still haven't come back from lunch over in Judge Dorow's because of the juror. Okay, let's go back and look at the flagpole. And seals. Okay, Allian posted a new video on one of these people who they call themselves auditors, kind of interfering with courts or police stops and so forth. And this one is a police stop. Not sure where it is. Let me look at the video. It says first time cop watcher gets what he deserves when he interferes with a traffic stop. So let's get this. Oops. Get this. Okay. Here we go.
I'm gonna walk on through.
Sir, you're not.
That's all I want. So
You don't have to leave. Please leave.
you
sir.
understand that.
Please leave. Why are you guys touching me?
Welcome back to the Van Balian channel, guys. Today we head to California to take a look at a video titled Assaulted and Arrested for Cop Watching, where a Chile de Castro acolyte interferes in a traffic stop and tests the patience of a very calm Clover police sergeant, but in the end gets exactly what he deserves. Right, let's get into the video.
Done. Oh, do me a favor. You're not able to come through here, sir. Please, if you would. I'll conduct an investigation.
Okay.
Yeah,
Do you have any tape up?
Yeah, let me have you walk across the street. I'll walk you across.
Okay. If you need to put some tape up, I can. Otherwise, this is a public.
This is a, sir, we're conducting
publicly
a
accessible
criminal
way.
investigation.
This is a publicly
Please,
accessible way. If you don't have tape
please,
up, I'm gonna
sir.
walk on through.
Sir, you're not.
I am,
I'm telling you, you cannot, sir.
and I can film you guys all I want. So
Okay, please don't come this way, sir.
okay,
Thank you. You can film from here, but not over here.
I can get within 8 feet.
Sir,
That's actually the
I'm
law.
not going to ask you
And you
again,
know
sir.
that.
I'm not going to ask you again.
You guys are funny. I love it.
This guy has unstable written all over him. Pair that with a complete misunderstanding of the law and police procedures, and you've got a giant pain in the ass on your hands. But that's what makes this arrest all the more satisfying.
But you're on video, so
That's fine, sir. So are
live
you.
stream actually.
So are you, sir.
Oh, you are watching now? I'm live streamed. Right, and that's actually kind of hard to get the body cam video. I'll get it, but it's a little bit harder.
Now you can walk through, sir.
No, that's all right. I'll think I'll spectate for a little while.
Feel free to walk through, sir.
I'll spectate for a little while. Thank you.
Not closer. Do not get close.
I'm plenty far away. I am plenty far away. A camera is not dangerous.
Sir, don't get closer. Just please continue to walk. You're free to go. You're continue to walk.
Thank you. You're free to go too. Thank you. You're dismissed. Yeah, you haven't confronted one of me yet. Fuck around and find out, dude.
Says the guy who is in fact effing around and who will in a few minutes find out. Also, I love how he sees every attempt by the officer to de-escalate the situation as a huge victory. And yes, as well as this being an officer safety issue, it's a safety issue for you because they have no idea who you are or why you are acting this deranged.
Please.
Sir, are you armed?
Am I
Are
armed?
you armed? Do you have a firearm?
I guess that would be none of your business, but
Are you armed, sir?
that would be none of your business.
Listen,
I don't answer
you're holding
questions.
an officer safety issue at this
I
point.
don't answer questions, and I'm just, I have a camera.
Please leave.
I have a phone, I have a camera.
Please leave, sir.
I don't answer questions. Thanks.
Well, that's interesting because he didn't ask you a question. He gave you an order to leave the scene twice, which you are either going to forget about or completely ignore.
They're a sheriff, huh? Interesting.
So because he didn't get the reaction he wanted recording the cars, he goes back to the tried and tested method of doing what he's been ordered not to do, which has always worked out so well for these guys in the past.
Right here, sir. Right here.
This is a publicly accessible
Sir,
way.
walk that way, sir.
I can walk on
Walk
through
that
all
way,
the.
please.
Are you
We're
blocking
dealing-
the publicly accessible
We're
way?
dealing with an emergency right now. It's a situation.
What's the
Please walk
emergency?
that way. Walk that way.
And even if it is an emergency, do you realize that's not a reason to violate people's rights?
Sir, I'm
People
asking-
still, their rights still stand,
Turn
whether
away
there's
that
an
way.
emergency or not.
Turn that way and go.
Sir, please move out of the way. This is a publicly accessible
Until we can
area.
secure our scene, sir, I'm asking you to please go that way.
And what have I done? How have I been threatening?
You
I have a
haven't done
camera.
anything wrong,
I have a
sir.
camera. Is this threatening to you? A
No,
camera?
It's not, sir. It's not.
Okay, then what's the problem?
Let's face it, the camera isn't the problem here, is it? It's the guy holding it. A guy who has already refused perfectly reasonable requests to not interfere in their investigation, and then 2 orders to leave the scene for not only officers' safety, but for yours as well, because who knows what that guy was being arrested for.
6 ball. 5
What is the problem? Please tell me.
Advise when you're secure there, so we can let this gentleman go through.
This is a publicly accessible area. I'm gonna walk on through. Thank you.
Listen, we're dealing with the situation.
I'm
sir.
walking by.
We're dealing with the situation.
Sir.
As soon as we secure the scene, then you can walk through.
Secure the scene. If
Yes.
there's a crime scene, you must put up tape.
We have
You know
some-
that.
We have somebody.
You really
we're
want to
dealing
screw
with,
it? You want to really press me on that? Right?
No,
all
sir,
right, let's
we're
do
trying to
it.
secure
We're gonna do it that
somebody
way.
right now.
That's
We're
fine.
trying to secure somebody, sir. I've asked you.
You know how many thousands of people do this stuff now because of the shit you guys
You
do?
can go that way, sir. You're
I'm
free to
live
go.
streaming. You know how many people are watching this?
That's fine, sir. You're free to go.
Exactly.
Go
But
now.
I'm gonna go that way.
Not until
And
we-
you're not gonna stop me.
not until we secure the
This
person
is a
that we have.
publicly accessible
We are
way.
securing
You're not
somebody
gonna
right now.
stop me.
So we're securing somebody right
Am
now.
I threatening to you at all?
No, absolutely not. Sir.
Okay, so then what's the problem?
As soon as we're securing our prisoner, then you can go, sir. Okay. Until then, you cannot go over there, sir.
You have not set up crime scene tape. That is required if you want to corn off a place.
Crime scene tape? What are you rambling on about? This is a traffic stop that led to an arrest, not a crime scene. Police can stop you from passing if they feel their safety or the safety of others is an issue, which is clearly the case here. Stop being a Karen and get some perspective.
An area.
There's half
You know that.
of open
It
free
doesn't
space
matter.
to walk through.
I'm here to record you, dumbass. You know that. Because of the stupid shit you guys do and get away with it. That's the problem. Don't you understand that? You guys are freaking horrible. You took this position to fuck people over and violate people's rights. Not all of you, but a lot of you have, and you can't say you haven't. And the people are sick of it. There's a movement, man. There's a rising. There's enough people that are freaking sick of it, dude. We're done with it. No, you can't tell me to leave. I'm in a publicly accessible area. I can tell you to fuck off just as much as you can tell me to leave right now. And you know that. If you don't, that's a problem.
Again, it's not your camera or your mouth that's the problem, although your all cops are big meanies rhetoric is just another one of Chili's talking points, which is concerning because it shows you lack any original thoughts of your own. It's about you continually walking up on them after being warned not to. That's all, and it will get you arrested.
a good night, sir.
Yeah. Have a good night. Thank you. Did you get some education? They told you in your ear to let me go by? They did, didn't they? Please. I'm not here to be a pain in the ass, but you guys do this stuff, and it's not okay.
Have a good night.
Too much stuff, not okay.
Good night, sir.
Thanks, you too. And I really do hope you guys are safe, stay safe, and do the right thing. That's what I want you guys to do. Thank you.
So he could have just left it at that, stood back and continued filming from a good spot, capturing all the footage he needs. But that's not very interesting for his viewers, is it, if we're being honest? Plus, his ego is way too big to leave it there, so he doubles down on the dumb.
Yeah, I know. I'm just gonna leave.
Just film my vehicle.
Okay. Sir, I don't want to take you to my
I'm
car.
a grown-ass man, dude.
If you can just
I
back
can
up, I'm gonna
completely
go to my
take
car.
care of myself. Thank you. I am a grown-ass man. Thank you. I do not need your instruction. Thank you, sir. I appreciate it, though.
If you fail to see the problem with walking out onto the street between parked cars, knowing what can happen in a split second, then yes, you do need to be told what to do, and you are not a grown-ass man, as you claim.
Yeah, you hate people like me because I stand for what's right and I stand for our rights. Freaking guys, man. What's your name and badge number? Name and badge number.
Corporal Williams.
Badge number?
132.
Thank you. Name and badge number, please.
Sergeant Satyan, ID number 5215.
Thank you. Name and badge number?
Officer Shahal,
Go ahead and head
5817.
back over to the PD.
Thank you.
Sir.
Appreciate it. Madera County Sheriff is all the way over here. Why? Let's look that up and find out why. Wonder what this poor guy did that they had to put him in torture cuffs. I'd like to ask, just to find out. You know, since we are in public, I'd like to ask, what did this poor guy do to get put in torture cuffs in the back of the car?
I'm not sure, but you're going to be wearing a pair soon on the way to, or when you get to jail. Anyway, now we ignore, which leads to the moment we've all.
All right. Attorney Kugler, the defense can call its next witness, please.
Thank you, Your Honor. The defense calls Dr. Lindsay Thomas.
Good afternoon, Dr. Thomas. If you would please make your way to the witness stand. When you get there, please remain standing, raise your right hand, and my clerk, Teresa, who's on my left, will swear you in.
You solemnly swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and spell each.
Lindsay, Lindsey, Thomas, Thomas.
Go ahead, Attorney Kugler.
Thank you. Good afternoon, Dr. Thomas. Make sure this is close enough. So I would like to have the jury get to know you a little bit. And in that regard, have I received from you your curriculum vitae?
Yes.
We call that a CV for short. Is that right?
Yes.
And Madam Clerk, could I show that to the witness on the screen, please? Kind of like a resume, right?
Right.
Now I'll show you, it'll come on your screen in a minute. Is it there yet?
It is.
All right. I would like to show you first the exhibit sticker. I've marked it as 625. Is that right?
Yes.
Can you look, and I'll page down for you. It appears that it's 10 pages.
Yes.
And should I page down so you can make sure this is yours?
No, I'm pretty sure it's mine.
Well, I'll page down just
All right.
very quickly. Okay.
Yes.
Is this your CV?
Yes.
Thank you. Your Honor, move for admission of exhibit 625.
No objection. All right, exhibit 625 is received. Permission to publish is granted.
Thank you. I'd like to publish. So you've divided your CV into employment and education and organizations and licenses, right? Right. So I would like to start down, even though you start out with employment. I'd like the jury to understand first what your educational background is, and in that regard, I put up page 2. I'll wait for the jury to have it on their screens. They do. Okay. So can you tell us about your educational background, please?
Sure. I have a bachelor's degree from Oberlin College in Ohio. Then I went to medical school at the University of Michigan in Ann Arbor and have a medical degree from there. Then I did a 4-year residency in anatomic and clinical pathology at University of Michigan. Then I did a 1-year fellowship in forensic pathology at the Hennepin County Medical Examiner's Office in Minneapolis, Minnesota.
And what is it? So are you a pathologist?
I am.
And what does it mean to be a pathologist?
Well, a pathologist is the physician who studies disease. So you might have an anatomic pathologist or a clinical pathologist, and I studied both of those. So anatomic pathology is, for example, if you have something biopsied and it gets sent to the lab, it would be a pathologist who looks at it under the microscope and says whether it's cancer or not. Clinical pathologists run laboratories, so if you have blood drawn, it would be a clinical pathologist that might interpret looking at the cells to see if you have leukemia or something like that. Then forensic pathology is a branch, a specialized branch of pathology that focuses on areas where medicine and law overlap. And as it's primarily practiced, as I primarily practiced it, it involved medical legal death investigation and doing autopsies.
So you've done autopsies throughout your career?
Yes.
Now if I look at page 3, if we all look at page 3, you have licenses. Are you licensed?
Yes.
In medicine and surgery?
Yes.
Do you have any board certifications?
I'm board certified in anatomic, clinical, and forensic pathology.
And you keep those certifications current?
I was lucky enough that when I took it, you didn't have to keep retaking it. So I'm grandmothered in.
For life?
For life, yes. But I maintain my certifications with continuing medical education.
And I was going to just ask you about that. So you take continuing medical education?
Yes.
You're required to do that as part of being a physician?
Yeah. This is maintaining my licenses.
You have to take so many credits a year?
Yes.
And you do that?
I do.
Are you a member of professional organizations?
Yes.
Which ones are of significance that you could tell the jury about today that you think are important?
Probably the 2 most important ones are the American Academy of Forensic Sciences, which is the organization of all forensic disciplines, including forensic pathology, and the National Association of Medical Examiners, which is the preeminent organization in the United States of medical examiners and forensic pathologists.
Now, I've heard about an organization called NAME, N-A-M-E.
Yes, that's the National Association of Medical Examiners.
Okay, and that's an association that medical examiners throughout the country belong to and follow standards of. Is that true?
Correct. They are an organization that creates standards for forensic pathologists and death investigation agencies to follow.
And it looks to me like you've been on even the board of directors and executive committees at different times in your career.
Yes.
I'd like to talk to you a little bit about your appointments. So what you've taught, I take it you've taught in the field of pathology.
Yes. Especially at the University of Minnesota, when I was affiliated with Hennepin County, I was one of the instructors for the pathology residents because they're learning about forensic pathology as part of their general rotations.
And then let's let the jury know what kind of work you've done over your career. So I'm going up to the top and of your CV. Can you give us a rundown of your positions?
Sure. I started at the Hennepin County Medical Examiner's Office and was there for a number of years. Then I moved to the Minnesota Regional, originally Coroner's Office, then Minnesota Regional Medical Examiner's Office. And I was the chief medical examiner there for 15 years. And then that office grew and we ended up merging with Hennepin County. So the last 4 years of my career, I was back at Hennepin County. And then since then, you can see at the top, I did work in other places around the country. There's a real shortage of forensic pathologists around the country. So almost every office needs additional help. So I would go and work for several days to fill in if someone was on vacation or out for if they were short-staffed. So I did that, as you can see, kind of all over the place.
And what about at the present time?
Currently, I am no longer doing autopsies in any of those places. I'm trying to retire, and but I still have a consulting practice, which is the kind of work that brings me here today.
Okay, so you stopped doing active autopsies maybe in 2022, is that
Yes.
about right?
Mhm.
Is that yes?
Yes.
Until just a year ago?
Yes.
All right. And now you're working as a consultant?
Yes.
And you were hired by the defense team in the case of Jessy Kurczewski, is that right?
That's right.
And as a consultant?
Yes.
Now, have you published in your career, published literature?
Yes.
And I think I can see that you have that on your CV, starting on page 4. It looks like there's a long list of publications. Is that right?
Well, it's not that long compared to some people, but considering how little I enjoy writing, it feels long to me.
Okay. And when you have been published, are these articles that have been accepted in actual medical publications and go through a peer review process?
So some of them are peer-reviewed journals, the Clinical Toxicology, International Journal of Legal Medicine, Clinical Biochemistry, Academic Forensic Pathology. Those would be considered peer review, meaning that you submit the article and then other people critique it and offer feedback. Some of these were just articles that I was asked to write for kind of informational articles for like the Minnesota Physician and things like that. So it wasn't a peer review.
Sure. And then you also list that you present and you lecture, is that right?
Yes.
And do you lecture for law enforcement?
Yes.
And other physicians?
Yes.
Defense attorneys?
Yes. Prosecutors,
Prosecutors.
med students, high school students, college students. I've spoken to all kinds of groups.
And you speak about death investigations, manner of death, those sorts of subjects. Is that true?
Correct.
Okay, we can take that exhibit down. Thank you. So Dr. Thomas, you said that you do consulting work and you're consulting with our team, is that right?
Yes.
And you're getting paid for your work, are you not?
Yes.
Can you tell the jury what you're being paid for your work?
Yes, I get paid $400 an hour. And so far I've put in about 14 hours plus whatever I have for today.
Okay. I'm going to pull up a new exhibit for the witness alone to look at, which is going to be exhibit 629. Here we go.
One more down.
I'm sorry, it's just not popping up so quickly for me. So let me move on from that. I'll come back to it in a little bit. I'm just not finding it. But the point is, it's an exhibit about other testimony you've done. You
yes.
provided an exhibit about that. Is that true?
That's true.
And although I can't pull it up on the screen right now, may I just show this witness exhibit 629? Go ahead. Thank you.
Yes.
And is this a 629 is what, an exhibit of your testimony as a consultant?
In the last 5 or 6 years.
Okay. You've testified, I noticed on here, in Minnesota versus Chauvin case.
Yes.
Who did you testify for in that case?
At the request of the prosecution.
That's it. Who was the person that was it Rodney King?
No, that was George Floyd who died.
Oh,
in
George
that
Floyd
case.
who died. Okay. And so that is a list of your testimony. Move for admission of exhibit 629, Your Honor.
Exhibit 629 is received.
So when you came on board on the case, did you receive documents and things to look at, paperwork?
Yes.
And ultimately, did you receive a lot of things?
Yes.
Can you give the jury an overview of the sorts of materials that well, before I do that, after you reviewed the materials and reviewed the case, did you prepare a report?
Yes.
And I'll show you what has been marked as exhibit 561. Ask you if you can identify this as your report.
I'll show you the exhibit sticker. And it looks to be 9 pages.
Yes.
Is that your report?
Yes.
I've moved for admission of 561, but not asking to publish.
No objection. Exhibit 561 is received. Okay.
So let's start and explain what you did in this case and how did you ultimately reach a conclusion?
Yes.
And you were asked to reach a conclusion, fair to say, on cause and manner of death of Lynn Hernan.
Yes.
And you ultimately did reach a conclusion.
Yes.
Before we get to a conclusion, can you explain to the jury what you received and what you did here?
So the way it works is, since I wasn't the pathologist who did the original autopsy, in order for me to understand, I will review all kinds of documents, and I can list those for you, and then answer the specific questions that are addressed to me, and that could vary depending on the case. In this case, it was cause and manner of death. So I reviewed the amended criminal complaint, and I'm referring to my report here.
Down, Madam Clerk.
The autopsy protocol and the amended autopsy protocol, what's called the fact of death certificate, an email from Detective Hoppy to Dr. Butzricki, the Waukesha County Office of the Medical Examiner investigative report, Waukesha County Sheriff's Department's reports, toxicology reports, report from Sherry Kachenko, PhD, scene and autopsy photographs, report from Henry Spiller, Daubert testimony of Dr. Butzricki, Dr. Kachenko, and Henry Spiller, ProHealth Waukesha Memorial Hospital records, Pewaukee Fire Department records, Aurora Healthcare records, Advanced Pain Management records, microscopic slides. So those would be sections of organs that were taken at the time of autopsy, and then they're embedded in paraffin wax and sliced very thin, put on a glass slide, and then stained. And you can make duplicate copies of those so that I could, in my home office, look at copies of those slides. And then an abstract from Dr. Kachenko.
I don't think she's a doctor, but.
Oh, PhD.
Oh, PhD. Okay. And so you reviewed all those materials, you studied them.
Yes.
Now, what background information about Lynn Hernan, if any, was significant to you?
Oh, well, I would say her past medical history was very significant. She had a very long list of medical conditions, and also had quite a few psychiatric disorders, and that's something that's very relevant when forensic pathologists are trying to figure out what the cause and manner of death might be. And also a history of what turned up positive on urine drug screens in her medical history, her recent hospitalization, and all of the illnesses associated with that, and also all of her various prescription medications. So that's the background information on her that we always want to know as much about a person as we can, because that often will help inform us about the cause of death. We don't, as forensic pathologists, we don't just get the cause of death from the autopsy, we get it from the history, the scene, the investigation, the autopsy, the toxicology, and then put all of that together.
So you said that she had psychological issues that played into your forming an opinion.
Yes.
What are those in particular?
She had depression, anxiety, agoraphobia, which is fear of public places, chronic insomnia. Those were the ones that were listed in her medical records.
Okay. And you mentioned about a urine drug screen. So is that the one from February 28th, 2018 that you're
Yes.
talking about? And what about that that's significant to you?
She had something that's called ethyl glucuronidase, which is due to ethanol or alcohol ingestion, and also temazepam, it's a type of drug that's like a benzodiazepine. It's a metabolite of diazepam or Valium, but she wasn't prescribed it. So whenever a patient who's on chronic medications, specifically pain medications or other benzodiazepines, turns up positive for something they're not supposed to be on, that's kind of a red flag, because it suggests that maybe they're getting medications from elsewhere and they may be at increased risk of a drug overdose if they're using their medication and other medications inappropriately.
You note that Ms. Hernan had that hospitalization September 15th to 28th. Is that right?
Yes.
That's 2018. That's shortly before her death, right?
Yes.
Did you find that to be important in your conclusions here.
Yes.
Why?
Well, she was very ill. She had acute kidney injury at that point. She had what are called metabolic disturbances, meaning that a lot of the chemicals in her blood, the calcium, the sodium, were too low. And so that suggests maybe she's malnourished or ill in some other kind of way. She had some elevated liver tests that suggest her liver wasn't functioning that well. And the other thing I think was important is that she met with a palliative care social worker. So she wasn't on hospice care, meaning that she was diagnosed as someone who's terminally ill and likely to die within 6 months. But meeting with palliative care suggests that there was a recognition that she was very chronically ill and probably not likely to recover in a significant way.
Did you notice in the records that when she was released from the hospital, it was with a condition that she'd have a full-time caregiver?
Yes.
Okay. Now, you said that there was an EKG that you mentioned in your report. Can you explain what that is and what it showed that you thought was important?
Sure. So an EKG is the measurement of the beating of the heart, and that showed what's called first-degree AV blocks. So it's a block between the atrium and the ventricle of the heart, just meaning that part of her electrical conduction system wasn't working properly. And in her case, it must not have been so severe that they felt she needed a pacemaker or a defibrillator or anything like that. But she did have episodes of what's called bradycardia, or slowing of the heart rate. So it certainly indicates that there was probably something going on with her heart, something wrong with her heart. And that did prove to be true at autopsy.
And did they do a CT of her liver as well?
Yes.
What did that show?
That showed what's called fatty infiltration of the liver. So it means that the cells of the liver are filled with fat. And there are lots of things that can cause that. Probably what you think of most frequently is excessive alcohol. And that can cause the liver to have this fatty change, or it's sometimes called hepatic steatosis.
I noticed that you then talk about the prescriptions that Ms. Hernan had at various times.
Yes.
Can you tell the jury the various prescriptions that Ms. Hernan had at various times?
Alprazolam, nifedipine, triamterene, cyclobenzaprine, synthroid, baclofen, as omeprazole, lidocaine, vancomycin, fluoroster, chlorperazine, vitamin D3, Nexium, sulfamethoxazole, TMP, which I can't remember what that stands for, it's an antibiotic, ropinirole, and hydrocodone acetaminophen.
That sounds like a lot of prescriptions.
It is a lot of prescriptions, I would agree.
What else do you talk then about her being found not conscious and not breathing?
Yes.
That's October 3rd, 2018, is that right?
Yes.
And she was in her chair?
Yes.
You mentioned that there was an apparent will on the floor. Did you find that important?
Yes.
And at the time of her death, what did you indicate at the time of her death, it appeared she might have taken excess pills. Is that right?
Yes.
Can you explain what your next paragraph
Sure.
is?
So when medical legal death investigators go to a scene, and especially if someone has a lot of prescriptions, and especially if it looks like the death may be related to drugs, they will do a very thorough inventory of what medications the person has been prescribed, when they were prescribed those, how many they were prescribed, what the directions are. So for example, she had been prescribed alprazolam. She'd been given 30 tablets on September 20th. And 13 days later, at the time of her death, there were 0 left in the container, and the directions were for 1 a day, so there should have been 17 left. Likewise, the nifedipine was prescribed on September 28th. There were 30 prescribed, and there were only 2 left, and that was also directions for 1 a day, so there should have been 28 left. And
28.
Sorry,
October 3rd.
3rd, 5 days later.
5
Yes,
days later.
25. Sorry.
So she should have had 25 left in her
instead of 2.
Instead of 2.
Yeah. And then also the hydrocodone acetaminophen, which is a strong pain medication. She had 20 prescribed on September 28th, and there were 0 left 5 days later. Now, the directions did say she could take 4 a day, so it's possible she was taking as described. In addition, there were some loose medications found at the scene, including alprazolam and hydrocodone. So it's possible that some of the missing medication ended up just loose at the scene.
Okay, I think it would be helpful if I bring out that exhibit, page 4. He has to publish at this point.
I'm gonna object to publication of 561.
I'm only going to publish portions.
Overruled. Page 4 may be published.
Wait till it shows up. Takes a while to show up for the jury. There. Okay. So what are you? What is page 4 of your report? Can you explain what we're looking at here?
Yes, so this is something that is completed by the medical examiner investigator. And you can see on the left is the list of all of her medications. And the next is the dosage, meaning how many milligrams each pill is, the prescription number, who the prescriber was, and then what date it was filled, pharmacy, and then the directions. And so that's important. For example, the first alprazolam, there were 30 prescribed on September 20th. She was supposed to take 1 a day, and there were 0 left. And you can go down the whole list. Now, for something that was prescribed in August, it wouldn't be surprising that there would be 0 left. So that's why it's important to note what date it was filled. I think, however, what's really significant about this is there's so many pill bottles with 0 left. That always sort of raises the question of what someone's intention was at the time they were taking their medications, that they went through and emptied all of the pill bottles.
And do you know whether or not some of these prescriptions were ones that Lynn was no longer supposed to be taking?
Yes. According to her medical records, she was no longer taking the hydrocodone, baclofen, and cyclobenzaprine. However, and so you can see the baclofen was last prescribed in February, and the cyclobenzaprine was last prescribed in December of 2017. And the hydrocodone was from September 28th. So even though she had previously stopped taking it, she had gotten this prescription refill.
Either a refill or a new prescription.
Right, right.
Although if the, okay. So then continuing down on that page, I see you show 5 pills, and we had a little bit of testimony about that a couple weeks ago. But why don't you explain what's next important about the autopsy?
So the autopsy showed obesity, which can be important because that can put people at risk for respiratory depression, for difficulty breathing due to the pressure on their chest. She had pulmonary edema, meaning that there was buildup of fluid in the lungs. That can be from a number of causes. It can be from heart failure, but it can also be from drug overdoses. So that's something important. She had what's called hypertensive cardiovascular disease, meaning that she had an enlarged heart, that's cardiomegaly, and it was from high blood pressure or hypertension. And she also had, with respect to her heart, she had 50% stenosis in the mid-left circumflex. So that means that a vessel that should be this open is only half that open, and that's sometimes called hardening of the arteries. And that can predispose someone to having a heart attack. She also had hepatic steatosis, which is the medical term for fat in the liver. So that confirmed the hospital diagnosis. And then she had something that's called interstitial myocarditis, and that's inflammatory cells in the heart muscle. And then these 5 pills, which were probably nifedipine, were found in her gastrointestinal tract.
So did you examine that?
Yes, and that confirmed that there was a very significant hepatic steatosis or fatty change in the liver, and there were multiple areas of this inflammation, this myocarditis.
Okay, let's move to the toxicology. So you said you reviewed a lot of things. One of them was a report from Sherry Kurczewski, is that right?
From Dr. Kurczewski, or from
Kurczewski.
Sherry, yes, I'm sorry, Sherry Kurczewski,
And
yes.
also number 7, toxicology reports.
Yes.
So that was from the NMS labs.
Yes.
We've heard about NMS labs and we've seen reports. Tell us what is the, I see the next paragraph discusses the toxicology. Can you explain to the jury what was found there?
Well, I think a couple of things are significant here. First, there's the tetrahydrozoline, which is not something that is normally found in my experience, but I have never looked for it. So, but I don't think it is a commonly used medication. She also had alprazolam, which was something she was prescribed. She had hydrocodone and hydrocodone metabolites. She had cyclobenzaprine in her blood, and that's significant because, as I mentioned, she hadn't been prescribed that recently. So that suggests that somehow she went back and found some old medication to take. She also had baclofen and ropinirole, nifedipine, and she did have a little bit of ethanol or alcohol in her stomach, but not in her blood. And then she also had triamterene and acetaminophen, which is like Tylenol. And they tested her blood for arsenic, but that was not significant.
And you're familiar with Sherry Kachinko's opinion about tetrahydrozoline?
Yes.
Okay. Are you personally, do you keep up on the literature as best you can?
As best I can. Probably not the tox literature as much as forensic pathology.
But are you aware, as you sit here today, of any cases of tetrahydrozoline overdose deaths reported in the medical, peer-reviewed medical literature?
No, I'm not aware of any.
None at all?
No.
I'd like to talk to you about your conclusions. And we can take the screen down right now. Did you come to a conclusion to a reasonable degree of medical certainty as to the cause and manner of Lynn Hernan's death?
Yes.
Let's talk first about the cause of death, if we could.
Okay.
What do you believe the cause of Lynn Hernan's death was?
It's my opinion that her death was due to mixed drug toxicity. And in that, I would include the tetrahydrozoline, baclofen, ropinirole, alprazolam, hydrocodone, cyclobenzaprine, and nifedipine. And the reason I would include all of those, even though the levels that were found in her blood were not extremely high, is that many of these may have what's considered an additive effect or a synergistic effect. And in addition, because she had presumably stopped taking some of these medications for quite a while, the mere presence of them in her blood is suggestive to me of that she may have taken them in excess. Additionally, the fact that there were 5 undigested pills found in her gastrointestinal tract, and the prescription was to take 1 at a time, so there would be no reason to have 5, suggests that she probably took even more than 5 because some of them were absorbed. So I think there's evidence that she had taken in excess of at least several of these. And so that's why I think I would include all of those as part of the cause of her death.
Do you call it a mixed drug toxicity?
Yes.
So meaning all these drugs combined together was really the cause of her death?
Yes, and sort of a corollary of that is I wouldn't pull out any one of them as being the cause of death because I don't think any one in and of themselves would necessarily have caused her death.
Okay, so you wouldn't be able to say, geez, the baclofen alone caused her death.
No, I wouldn't. No.
Or the tetrahydrozoline.
Right.
None of them alone.
Right.
It's the combination together.
Yes.
In your opinion.
That's my opinion.
Did she have any other significant contributing conditions that may have led to her death as well?
Yes. So on a death certificate, and part of the job of the medical examiner is to complete the death certificate, there's one section for the cause of death. And so that's where I would put mixed drug toxicity and list all of those drugs that I mentioned. There's a second category that's called other significant contributing conditions. And that's where there are diseases or processes that may have made someone more susceptible to dying in whatever the actual cause of death was. So for example, a elderly person who falls and breaks a hip may end up dying because of the hip fracture, whereas a healthy young person wouldn't. And in that case, I would list under other conditions, well, maybe they had heart disease and lung disease and things like that that made them more susceptible. So in her case, in this particular case, Ms. Hernan's case, she had this interstitial myocarditis, the inflammation in the heart, as well as having clinical evidence that she actually had something wrong with her heart. We talked about the EKG and the slowing of her heart rate. So I think that may have made her more susceptible to the potential cardiac or heart effects of some of these drugs. She also had hypertensive cardiovascular disease with an enlarged heart. And we think of people as, oh, they're big hearted, like that would be a good thing. But in fact, an enlarged heart is not a good thing. And people with larger hearts are at increased risk of having what's called an arrhythmia, or abnormal beating of the heart, which can cause sudden death. So I would list that as a risk factor because that also makes her more susceptible to the potential cardiac effects of these drugs. She also had the hepatic steatosis, the fatty change that we've talked about. And I think that can contribute because it can affect how drugs are metabolized. A lot of drugs are metabolized in the liver, and if your liver isn't working properly, then that could have an effect. And also suggests that she may have had some other underlying diseases that could be contributing. And then she also had a history of chronic obstructive pulmonary disease, which is lung disease. And that would make her more susceptible to the potential respiratory depression or breathing slowing that can happen with some drugs. So I would list all of those things.
Well, you mentioned hepatic steatosis.
Yes.
That's a fatty liver.
Yes.
How do you get a fatty liver?
Well, there are a number of things that can cause a fatty liver. Probably the most common is alcohol ingestion. And if people use a large amount of alcohol over a prolonged period of time, it can really affect their liver. And people with liver disease like that, it sort of suggests that they may have taken more alcohol than was healthy for their body. And in her case, that may have been a contributing factor because there was evidence during her prior hospitalization that she did have some abnormal electrolytes or chemicals and also liver enzymes. So she may have had complications from that.
You know, when you talk about the toxicology test that came back, but what if her tox had come back negative? Would any of these conditions, could they be a cause of death?
Absolutely. I would especially consider the myocarditis, the inflammation in the heart. If she had nothing else, if her tox was completely negative, but she had this severe heart disease, I wouldn't hesitate to call that the cause of her death. But that's why it's so important. You don't just make the determination based on the autopsy findings. You have to put it all in context.
And that's what you did. You put everything together. Is that right?
Right.
Okay. All right, that's cause of death. The other thing that a medical examiner or a pathologist has to opine about is manner of death, right?
Yes.
Okay, and there's different categories of manner of death.
Yes.
There's 5, as I understand it.
Yes.
Is that right? What are the 5 manners of death?
So there's natural, meaning that the death was the result of diseases that were natural. There's accident, meaning that there's some external injury. It could also be drug overdoses are considered accidents if they aren't taken intentionally. Then there's suicide, meaning that the death is self-inflicted and there's some element of intent. There's homicide, meaning the death is at the hands of another person. From the medical examiner perspective, that doesn't imply criminal intent. So what people might consider a hunting accident, for example, one person shoots another person not intentionally, we would call that a homicide because it's death at the hands of another, but it certainly doesn't mean that it needs to be prosecuted or anything like that. So it's a separate medical category of homicide that doesn't necessarily correlate to the legal system. And then the 5th is undetermined or could not be determined. And that is a category that's used either where we simply have no information about what happened, you know, a body is just found and there's nothing to suggest what happened, or there's information that supports one or more of these other categories. So probably the most common is a drug overdose, where yes, they may have a history of depression and some other factors that might be considered risk factors for suicide, but they also have a history of maybe taking too much of medication or just inadvertently taking drugs that they weren't prescribed. So that is probably the most common place that we use undetermined, would be a situation like this, where there's evidence that it could be a suicide or an accident. You can't always rule out a homicide. So then you use undetermined because that's sort of the most honest appraisal of all of the information that you have.
So in this case, using your most honest appraisal of all the information you have, did you reach a conclusion of manner of death for Lynn Hernan?
Yes, and I would say that was undetermined.
Okay. You think that's the best classification for her death?
Yes.
You've considered all the other categories?
Yes.
And let's talk about it.
Mm-hmm.
Now, the 5 categories of manner of death, that is also found in the NAME publication. They also list the 5 possible manners of death. Is that right?
Yes.
And then have you even taken a look at Wisconsin death certificate forms themselves to see if those 5 categories are listed on it?
Yes, those 5 categories. Plus there's a category called pending, but that isn't a permanent category. That's just you put if the funeral home needs the death certificate and you haven't finished your investigation yet. So there are actually 6, but really only 5.
Okay, this isn't a pending situation.
No.
But if you had one, you'd have to go back and change it eventually, right?
Yes, it's called unpenned.
Okay. Now, would you say that there is strong evidence here that Lynn Hernan's death was a suicide?
I would say there's strong evidence that it certainly could have been a suicide. Yes.
What factors would contribute to your opinion?
Well, there are a number of articles that we as forensic pathologists reference when we're trying to figure out if something might be a suicide. They're published by the CDC, the Centers for Disease Control, and they list a number of risk factors that might include mental health issues, great emotional or physical pain, rehearsing fatal behavior, trying to avoid being found, the recent legal problems, recent medical problems. There's a whole list of things. But I think with respect to this case, certainly Ms. Hernan had expressed emotional and physical pain and distress. I think her recent hospitalization, she was very frustrated and upset that they couldn't really cure her, that she still had all of these symptoms and problems. She certainly had a history of mental illness, depression, agoraphobia, anxiety, chronic insomnia. She had serious illnesses, which is a known risk factor. And she had a history of substance use disorder, potentially, as suggested by that positive drug screen that she had in, I think it was February of 2018, suggesting that she was taking a medication that she wasn't prescribed, as well as alcohol, which is usually not a good mixture. And then she certainly had easy access to lethal means in the forms of all of her medication. If she had been not taking all of her medication the way it was originally prescribed, she could have had a little backlog of pills, and that certainly is suggested by the toxicology.
Doctor, among those things, did you also, although it may not have been testified to in trial, did you have access to the police reports in this case?
Yes.
And did you have a statement from Ms. Hernan's neighbor on this issue?
Yes.
What statement did you rely on that statement?
Well, I wouldn't. Yeah, I mean, it was something I knew about, and to the extent that it fit in with the rest of her medical history, that was more verified. But her neighbor implied that she felt she had some suicide ideations.
The neighbor thought that Lynn had suicide ideations.
Yes.
And you saw that in a police report.
Yes.
Okay. So is it, you cite in your report a CDC document on the criteria for determining suicide. Is that something that you rely upon in your making your opinions here?
For me, it's so integrated at this point that it isn't like every time I have a case, I pull it up. But whenever I'm trying to explain to someone else who's not a forensic pathologist how we make the determination of suicide, it's a document I often reference because I think it's very helpful to understand from our perspective what we look at when we're trying to make a determination of suicide.
So do they indicate in that guide that they look to see if they can see any signs of intent in the person who's died, the deceased?
Yes.
And that could be written or verbal statements, right?
Yes.
And maybe preparations for death.
Yes, and so to that extent, the presence of the will could be considered that she wanted to get her affairs in order. Now, whether that was because she had met with palliative care and she felt she was dying a natural death, or it certainly could be that she was preparing her own death and was making those arrangements. So that certainly could be considered making preparations.
Or the document that you would have seen in discovery of her writing an obituary, for example.
Right.
What about things like, did you notice that in the scene photos of Lynn Hernan that she had her father's dog tags on?
Yes.
Might that be some sort of an indication?
I guess it would depend. If it was something she always wore, then maybe not. But if it wasn't something that she always wore, then that might suggest she was planning on being closer to her father, or she wanted to be comforted, or, I mean, there's all kinds of potential explanations.
What about an accident? Is there any evidence in the record for Lynn Hernan that her death could have been an accident?
Well, it could have been an accident in that she obviously had taken medication inappropriately in the past. And, maybe she was just trying to get rid of her pain or treat some underlying, whether it was psychological or physical pain, and just thought if she kept taking more, she would feel better. So, that's always a possibility.
Some people take drugs to get an effect from them.
Oh, sure, to get high. And maybe that's where the tetrahydrozoline came in, that it maybe is something that people get high on. I don't think so, but people do take all kinds of strange things.
Okay, so still, even though it could have been, it's an accident is possible, a suicide is possible.
Yes.
Your final conclusion is undetermined?
Yes.
When you looked at the autopsy information, and you had autopsy photos, right?
Yes.
So you saw, we don't need to show them, but you looked at all the photos as Dr. B, we call her, was making her different incisions in Lynn Hernan and taking a look at the inside of her body.
Yes.
Did you take note of anything involving Lynn Hernan's throat or Lynn Hernan's neck that would show whether or not there were any signs of any forced ingestion?
Right. No, the medical examiner didn't describe anything like that and didn't photo document anything like that.
And it would be documented if there was.
Yes.
Because as a medical examiner or a pathologist, when you're doing an autopsy, anything significant, you take a photo of, true?
Yeah. Yes.
And you would also take a sample of and make one of those slices you were talking about and make a slide of it.
Yes.
If you wanted to look at it closer under a microscope, for instance.
Yes.
And that's what you're taught to do. Any of those significant findings are documented.
Yes.
None here as to the throat or mouth. Is that true?
Right.
And if somebody was forced to ingest some quantity of medications like we're talking about here, would you, as a medical pathologist, expect to see some sign?
I would expect there would be some injuries, or if someone were being forced to drink something, I would think they might gag and maybe inhale some of the liquid, and there wasn't any evidence of any of that.
And so could you tell the jury your final conclusion here?
So my final conclusion is that the cause of her death was mixed drug toxicity due to tetrahydrozoline, baclofen, ropinirole, alprazolam, hydrocodone, cyclobenzaprine, and nifedipine, and that other significant conditions contributing to her death were the interstitial myocarditis, the hypertensive cardiovascular disease with cardiomegaly, hepatic steatosis, and chronic obstructive pulmonary disease, and the manner of her death was undetermined, could not be determined.
Thank you. And do you hold your opinions here to a reasonable degree of medical certainty?
Yes.
I thank you, Dr. Cross-exam.
Right, I'm going to actually excuse the jury for a moment. So all rise for the jury, please.
Okay, I suspect we're going to discuss how long
You can all
This
have a
is gonna
seat.
go-
I'll wait till the second door closes.
because we are Well, let's see. I guess it's only 3:30.
So as this witness was testifying and I had an opportunity to see the redactions and kind of considering when in time really we had this report and some of the redactions that I know were agreed upon, but some of them had to do with references to alcoholism. And I think it's very different that when from an evidentiary standpoint, where individuals may talk about things that happened a year prior. Although some of that comes in for a variety of different reasons, but there's a difference when you have a medical expert and someone in pathology who is trained and has experience in looking at things like the liver and these slides. And when I talk about timing, this particular expert was added to the defense witness list after the trial in February was adjourned for the very specific purpose of the defense being able to locate a pathologist, in part, my perspective, because of the limitations I put on Mr. Spiller. And so the defense followed the trial order and filed an appropriate witness list with the defense expert report, curriculum vitae, and there was a time for the filing of any objections. Of course, it was specific related to Daubert. And none was filed. And while I understand the state's position about these references to Ms. Hernan being an alcoholic, after I've listened to the testimony of this witness and she talked about why history is important and how background information informing an opinion, I'm going to reverse myself on whether the report needs to be redacted and whether this witness can be questioned about specifically alcoholism. There's been ample testimony on this record. We've gone through a number of witnesses, including the medical examiner, including now this witness, and frankly others, regarding the medical records. And this is a condition that was noted by Dr. Bidzricki in terms of another significant condition. And I think it's not fair from a due process standpoint to limit the defense from going into that. It goes to the weight, potentially, any cross-examination, but not admissibility. I still stand by the part of the report that needs to be redacted as it relates to Mr. Spiller, because that was a very clear ruling I had made following the Daubert hearing that I did not believe he was qualified to opine on cause or manner of death. And so I'm looking at page 6 of this particular witness's report. I'm not saying she can't be questioned about that if a party feels it appropriate, but I don't think that should go before the jury if they do request this report or even in publication, because it's not an opinion that they will hear during testimony of Mr. Spiller. So that, I believe, the redactions on page 2, page 6. No, hold on. I don't have them. On page 6, it's a little bit different issue, but I don't see why the phrase "as well as the drugs listed by Mr. Spiller to include nifedipine." It doesn't tell this jury anything about his opinion, but I'm not positive about that. I need to reference his report, but in any event, page 7, there's a reference as Attorney Kugler indicated. I'm comparing 2 documents. That's why I'm going back and forth. I think that would be it. So I'm reversing myself, and Attorney Kugler, if you want an opportunity to question further on that, that's why I excused the jury, so that you were aware of that. And I'm not seeking any further comment by any party. This is an expert witness. It goes to weight, not admissibility, notwithstanding some of the limitations that I've placed. But when considering the gravity of the charges against Ms. Kurczewski and this particular witness's credentials, I think it's important that she be allowed to be questioned on that. Now, with that, I need a very short comfort break before we continue. So I'm just going to step off if anyone else needs that. And then I will let the jury know when we come back that I've allowing Attorney Kukler to continue with questioning.
Thank you.
All right, we are in recess just for a brief moment.
Okay. Yes, let's see. We were looking at this this male Karen interfering with the traffic stop. And you know, if they allowed this guy to go walking down the sidewalk during the middle of this arrest and something happened to the guy, the jurisdiction could be sued, and that's why they aren't letting the guy walk down the sidewalk. But anyway, let's finish it off because there's just a few minutes. So
Waiting for.
Sir, you're free to go, sir. That way.
I know I'm free to go. I'm free to stay also.
You're not
So-
involved in this investigation, sir. Just please leave.
Exactly. But I'm free to stay. So what did this guy do to be put in torture cuffs?
I would.
How you doing?
Can we coordinate? How are you?
Hi. What's your name and badge number?
Don't worry about it. Was that sir? So,
You must identify, please. What's your name and badge number?
it's Officer Friedenberger. Sir, you're a little busy, sir.
Name and badge number,
It's a little
please.
busy, Officer Friedenberger.
Name
sir.
and badge number, please. That is your policy. You must identify. What is your name and badge number?
I'm not gonna have you walk behind me. Go walk over there.
What is your name and badge number? Am I threatening with a camera? I have a camera.
Well, I have your
I
name.
have a phone, a camera. What's your name and badge number?
Don't worry about
Real quick, done.
Don't worry about it.
What's your name and badge number?
Don't worry about it.
Don't worry about it.
Oh.
I need to be able to.
This is the guy we arrested for a gun last time. 2 weeks ago.
You're arrested for a gun.
Sir, please leave.
What's your name and badge number, ma'am?
Sir, please leave.
I don't have to leave.
Please leave,
You
sir.
understand that.
Please leave.
Why are you guys touching me? Hey! Hey, everybody!
Well, I think everyone except him saw that arrest coming a mile off. Obviously, he was too oblivious and too wrapped up in his chilly talking points to see what we could all see. But isn't that always the case with these guys? Anyway, according to this reply to a comment in the original video, he was charged with obstructing an officer. Yeah, no shit. But he also argues that obstruction is a physical act and performing a constitutionally protected activity cannot be obstruction. Well, I would say if you're stupid enough to use chilly talking points out on the streets and in court, then you deserve everything coming your way. Right, thank you so much for watching, guys. If you enjoyed this video, then please leave me a like, share the video, and subscribe to the channel.
Okay, that was fun. Yeah, I mean, he's just looking for content for you know, his channel and so forth, and you know, he's creating something out of nothing. There wasn't anything going on really, and so he became the incident. So let's, oops, wrong tab. Let's go back to our flagpole here, and we'll see if there are any other short things here that we can take a quick look at. Let's see, did they... let me check Twitter to see if there's anything on the verdict on the Take Care of Maya trial. I haven't got into that one. I didn't have anything. I mean, I don't have a streaming service, so I didn't see the documentary. Nothing on the verdict. Let me take a quick look at see if there's anything here on YouTube.
Thank you. Please be seated.
Oh, here we go.
We're just waiting for. All right, we are back on the record. I also want to have this report. So that's another reason I didn't state that. I was trying to verify that by looking through the court records, but it's at the time all the motions in limine were previously decided. It was prior to the schedule or prior to February, is before the trial was scheduled in February, is when I made all those rulings. And again, I didn't even have this report to. I'll just advise them that I'm giving you an opportunity to ask some additional questions.
Okay, just need a couple questions.
I'm sorry? Thank you, everyone. Please be seated. Before I turn to the state for cross, I am going to give Attorney Kukler an opportunity to ask some additional questions. So go ahead, Attorney Kukler.
Thank you, Your Honor. So, Dr. Thomas, I'd like to just talk to you about this fatty liver and some lines of questioning around that. I heard you say that that can be a sign of of excess alcohol intake. Is that right?
Yes.
Did you have information in this record, the record that you reviewed, about whether Ms. Hernan had any history of alcoholism?
Yes.
Can you tell the jury what about that?
So in her medical records, she had, as I mentioned, elevated liver tests that would suggest she had some ongoing liver damage. In her medical record, there was this positive test for ethylglucuronide indicating use of alcohol. And then additionally, in the police report, I believe one of her neighbors said that she thought Ms. Hernan consumed a lot of alcohol or excess amount and suffered from alcoholism.
The neighbor thought that Ms. Hernan was an alcoholic.
Yes.
As well. Okay, thank you, doctor. That's all I have, Judge.
All right, thank you. Cross.
Thank you, Judge. Doctor, I'd like to ask you some questions about your report, kind of moving through it, and in terms of some things you testified to today. One of the discussions that you just had was about the urine drug screen that was really significant to you in the analysis of this case, right?
Yes.
And on page
a factor, yes.
Okay, but that was a screen that was done, you'd agree with me, many months before the death.
From February to October.
Okay.
Yes.
And do you know what lab the physician used for that urine screen?
Not off the top of my head, no.
Do you know whether there any confirmation tests were done of that screen? Of the results of that urine screen by any doctor?
Well, a number was given for the ethylglucuronide of 7355, but not for the temazepam as far as I know.
And so you don't know whether that number, for example, was confirmed as accurate?
Right, I don't know about the testing.
Okay, so you'd agree with me that there's a variety of different types of testing that can be done for controlled substances in urine?
Yes.
Okay, and some of them are much more reliable than others, fair?
Yes.
Okay. You've indicated here today some things that you've taken into consideration regarding what a neighbor said. Did you speak with Jean Tennell?
No.
Okay, so it would be really restricted to anything that would have been written by law enforcement, is that fair?
Yes.
Are you aware that on the day that Lynn Hernan died, Ms. Tennell told law enforcement Lynn was not suicidal and had never given her the impression that Lynn would be suicidal?
I was aware that there were differences in statements, yes.
Starting with Lynn was not ever suicidal on the day of the death, right?
That was one of her statements, yes.
And that's the same neighbor that you've referred to with Attorney Kukler today?
Yes, I believe it is.
In terms of the palliative care consult during Ms. Hernan's hospitalization, I know the jury has heard about this many times at this point. What I'd like to do is display an exhibit that I've prepared. It's a portion of the medical records in this case. It's states 233, and display that to the witness, please. It's an excerpt of exhibit 541.
You said 541, right?
Yes.
Okay.
The exhibit is an excerpt of 541. I've labeled it states 233. And doctor, just let me know when you can see that on your screen.
Yes.
Does that look familiar to you in terms of that palliative care consult that happened at Waukesha Memorial Hospital?
Yes.
And you'd agree with me that the reason for that consult was to try to help Ms. Hernan with symptom control, right?
Yes.
And she was in tears a lot and essentially really did not want to have to do a colonoscopy, right?
Right.
And then ultimately, after the palliative care team indicated there was no life-limiting illness and we signed off, right?
Yes,
Okay.
that was their impression.
And there was no palliative needs, and they never met with Ms. Hernan again, right?
Right.
Okay. And this was not as she left the hospital on the 28th. This is during the days that she was in the hospital, correct?
Yes.
Okay. You'd agree with me that nothing in the record indicates that that palliative care team told Lynn Hernan, you're dying, and there's nothing we can do about it.
No, no.
Okay.
No, if they thought she was dying, they would have recommended hospice.
Okay.
Not just.
I'd move 233 into evidence.
It's part of 541.
It's been highlighted and annotated. I'm moving it into evidence as 233.
Exhibit 233 is received.
Doctor, you talked about, and that can come down. Thank you. Doctor, you talked about the EKG of Ms. Hernan during that hospitalization as well, right?
Yes.
And that it showed first degree AV block.
Yes.
Is AV a short term for atrioventricular block?
Yes.
And are you aware of a peer-reviewed publication from 2021 that complete atrioventricular block can be due to tetrahydrozoline consumption?
I was not aware of that.
Okay. Were you aware that in the literature, tetrahydrozoline can also cause bradycardia?
Ooh, I don't remember that.
Okay. But nonetheless, you've noted that in the medical records from Lynn Hernan's hospitalization, both of those issues existed.
Yes.
Okay. In terms of your discussion of the medication inventory that is on page 4 of your report, you testified that the fact that many of these bottles are at 0 raises questions of Ms. Hernan's intent when emptying out the pill bottles. Do you remember that?
Yes.
You'd agree with me that a possible alternative reason that these pill bottles were empty was that someone who might have staged a scene just threw them out. That's possible.
Sure.
And you certainly can't say, based simply on the lack of tablets, that Lynn Hernan voluntarily took any of these medications.
Well, I know from the toxicology that she took many of these medications, but with respect to the 0 tablets, I don't know how that happened.
Sure. And you also testified that the cyclobenzaprine toxicology level in Ms. Hernan suggested that Ms. Hernan looked for and found an old prescription and took them. Do you remember saying that?
Yes.
Doctor, you're aware that tetrahydrozoline causes a sedated state when
Yes.
consumed, right?
Yes.
And that people involved in nefarious sexual assault type cases use tetrahydrozoline to subdue their victims.
Yes, I've heard of it used as a date rape drug.
Okay. So you'd agree with me that another possible reason that any of these medications are in Lynn Hernan's system is that she was given them while in a sedated and drugged state from the tetrahydrozoline.
Yes.
It's possible.
That's possible.
Because you weren't there and you obviously you don't know what happened, right?
Right.
Okay. So you really can't tell this jury whether any of these medications were given to Ms. Hernan by someone else or whether she found them and took them herself, right?
Right.
When we were discussing the toxicology, I noticed that you used the term medication when you referred to the tetrahydrozoline. I think you said that's not a commonly used medication, right?
It's not a commonly tested for medication, I should clarify.
Okay.
I mean, it's in eye drops. It's probably very commonly used.
In your eye.
In your eyes, exactly.
Right.
Right.
So when you say not commonly used, are you talking about people drinking it?
As far as I know, that is not in a common use. Yes.
In fact, there's no medical purpose to prescribe someone to drink tetrahydrozoline.
No.
Okay.
Not that I'm aware of.
It's dangerous, right?
Yeah.
Right.
Well, doesn't do any good.
In terms of the other medical issues with Ms. Hernan that you've talked about in your report, like the pulmonary edema, hypertensive cardiovascular disease, hepatic steatosis, interstitial myocarditis, you'd agree that all of those things are also in the autopsy protocol put together by Dr. Budritsky in this case.
Yes.
So it's not in any way a suggestion that she missed these things.
Oh, no, she absolutely diagnosed all those things.
Okay.
Yeah.
And you were asked some questions that had Lynn Hernan's death occurred and you reviewed the case for cause and manner and there was nothing in the toxicology, you'd have no hesitation of calling this interstitial myocarditis as a cause of death, right?
That would be my leading thought, yes, in
Right.
the absence of medications or drugs.
And I just want to clarify that in that scenario, we're assuming that Lynn Hernan nonetheless died, right?
Yes.
Okay, so what if I asked you whether we took away all the toxicology in this case? Are you telling the jury that nonetheless Lynn Hernan would die because of the myocarditis?
No, I have no idea. I mean, what I know is when people die and they have this degree of myocarditis, I would not hesitate to attribute the death to that. But there are probably people out there walking around who have myocarditis that don't die of it.
Okay, I just wanted to clarify that point. You also testified that you really wouldn't pull any of those drugs from the toxicology out as a single cause of death here, right?
Right.
Doctor, do you believe that had every fact in this case remained the same, except for the tetrahydrozoline, that Lynn Hernan would have died nonetheless?
Well, that's why I say you can't pull out, I can't pull out any one drug. I think it's possible, given her underlying condition and all of these other medications, that she certainly could have died. But I can't really speculate because the facts that we have are that there was the tetrahydrozoline.
Well, as a doctor, I think that you've experienced when you testify being asked hypothetical questions, right?
Sure.
And you'd agree with me that the tetrahydrozoline level in this case is significantly higher than a level found in someone using that substance as eye drops.
Absolutely.
Okay. And you'd agree with me that there are instances in the literature of levels much lower than Lynn Hernan's that cause people to, for example, wind up in ICU.
Yes.
And many of those studies involving people that survived, right?
Yes.
And you'd agree with me that all of the people that survived in those studies received medical intervention, right?
Yes.
Okay. You'd agree with me, doctor, that the hepatic steatosis could qualify as an underlying disease that could impact metabolism levels, right?
Yes.
In Ms. Hernan?
Yes.
Okay. So that would be something that's really important to know about if you were going to do any kind of calculation on the toxicology levels in this case.
I guess I don't know how that plays into it, calculating. I would defer to a toxicologist to talk about that.
When you, in all of your experience, have made these determinations about cause and manner of death, was it common for you to contact a toxicologist and say, here's the list of the toxicology. I want you to calculate for me how many pills this person took to get to these levels?
That was often a discussion we would have at toxicology rounds, we called it. And we would do that sort of exercise of, okay, this is the drug level. These were the pills. This was the dosage. What range of pills might someone take to get to that number? But we know it's really a guess, because it's sort of like trying to solve a algebra equation where you only have one of the three important, x plus times y equals z or whatever, because you don't know when they took it. And of course, the timing is important, and you don't know how much they took. And all we know is what the number was when we tested it. And of course, there's so many things that affect that. So it's an exercise that I've often engaged in, just to get a sense of, well, did they take 1 or 2 pills, or was it more like 15? Because that's helpful then in terms of trying to determine manner of death.
But in terms of what you're looking at in toxicology, you'd agree that substances that are in the blood are the substances that were affecting that person before death.
Absolutely.
And that levels of substances in, for example, gastric fluid has no bearing on the blood levels someone had at the time of death.
The value to me of gastric levels is, if it's very high, it might suggest a large ingestion as opposed to a smaller ingestion. But it totally depends on the timing, how rapidly something gets absorbed. Is it something that's absorbed in the stomach or the small bowel? Or so the actual number from the gastric contents is rarely going to really decide a case one way or another.
In terms of the decisions that you have to make, right?
Right.
Okay. And you'd agree with me that in doing those calculations that you just talked about, if someone has medical issues that affects their metabolization rates, that would be really important to know.
Well, you might know it, but you wouldn't necessarily know how it affects. I mean, it would be worth acknowledging that this person had liver disease or kidney disease, and that certainly could affect their metabolism, and we don't know how. I don't know if that answers your question.
Sure. You said it's kind of a guess when you're trying to go backwards from a post-mortem sample into what a dose might have been, right?
Exactly.
Okay. And so that may be part of the underpinning reason why the American Board of Toxicologists, forensic toxicologists, says that you absolutely should never do a calculation like that, reversing from a postmortem sample. Are you aware of that?
Yes, and I certainly agree that you can't do it and then testify, oh, these are the facts. Where I've found it useful, as I mentioned, is in sort of trying to say, well, is it more likely 1 or 2 pills, or is it more likely 15? Because then it helps maybe give an idea of what the intention was.
I'd like to publish State's Exhibit 34, please, the autopsy protocol. That's already in evidence.
Go ahead.
Doctor, you've obviously seen this protocol before, right?
Yes.
And you're familiar with Dr. Budritsky, right?
Yep.
Okay. I want to go, please, to the middle to lower half of the page here. So you'd agree with me that both you and Dr. Budritsky have indicated in your final opinions that other significant conditions include those medical or health issues that Lynn Herndon had, right?
Exactly, yes.
So those pieces of the opinion side by side are actually the same, right?
Exactly.
And you'd agree with me that all of the tetrahydrozoline and the other medications listed under other significant conditions are also included in your determination of cause of death.
Yes, the only one I added was the nifedipine to her list. But yeah, otherwise I agree, all of those drugs.
And so the difference really is the line where Dr. Budritsky put it, as opposed to above under cause of death versus below under other significant conditions.
Right.
Okay. You testified that you've worked about 14 hours on this case for the defense, right?
Yes.
And are those 14 hours before you got here into Wisconsin?
Well, I live in Wisconsin, so it was before I left my home this morning. Let's put it that way.
So during those 14 hours, you reviewed all the medical records in this case, right? That's on your list.
Yes.
And ultimately concluded and finalized the report that the jury saw some of, right?
Right.
In terms of, that 14 hours, how much time do you think you spent on trying to familiarize yourself with tetrahydrozoline and its effects?
Well, I spent some time because I remembered a presentation on using Visine as a date rape drug from many years ago. So I reached out to that author and talked, but mostly I was spending the time reviewing the medical records. Probably that's usually what takes the most time.
And you would agree with me that in all those, it's in excess of 1,000 pages of medical records, no doctor ever diagnosed Lynn Hernan as an alcoholic, true?
I did not see that in the record. That's right.
So in terms of this time that you've spent kind of familiarizing yourself with tetrahydrozoline, did you come across any study or any literature or even any media reports that tetrahydrozoline is commonly used recreationally because it gets you high or buzzed up?
I'm not aware of that.
Okay. That doesn't sound right to you.
No, that's not typically what's in the media. It's more like a date rape.
Anything in those medical records that you looked at indicating Ms. Hernan could not swallow pills, had to crush her pills up because she couldn't swallow them?
I don't think so. I mean, she certainly had gastritis and reflux and sort of that kind of thing, but she had nausea with vomiting, but nothing that said she had trouble swallowing.
And you saw in those medical records many instances where Lynn Hernan reported different symptoms or side effects she got from meds that she didn't like, right?
Yeah.
I want to ask you, you were shown a list of times that you've testified before, and specifically you testified in Milwaukee in the Mark Jensen trial, right?
Yes. Was that Milwaukee or?
Kenosha, sorry.
Kenosha, yeah. I was going to say, I don't think it was the big city.
And in that instance, you were again hired by the defense team, right?
Yes.
And similarly, in that case, your ultimate opinion there about manner of death was different from what the state medical examiner opinion was, right?
I think my opinion was undetermined, and I assume their opinion was homicide. I don't remember.
Okay. And in terms of what options you have when determining a manner of death, is there anything in the medical field or pathology field that would prohibit a medical examiner from using undetermined 95% of the time?
Well, peer group pressure. I mean, in our training, what I know from working in a lot of different offices is less than 10% of the cases end up being signed out as undetermined. And I think if there were an office that had 90% undetermined, when someone came to review that office, that would raise a lot of questions about the quality of the investigation. So it's completely understood that there will be 5 to maybe 10% undetermined, but more than that would raise a lot of questions, I think.
In terms of your current work in a consulting capacity, would you say that your amount of times you're making an undetermined cause of death exceeds that 5 to 10% of cases you review?
Oh, what a good question. No, it's, I mean, most of the time I agree with the original forensic pathologist in the cases I'm consulted on. So probably the only cases that I end up testifying is where I have a difference of opinion. So overall, I would say mostly I end up agreeing either it's a homicide or the manner of death isn't the issue or something like that.
And in this case specifically, you testified that there's evidence of suicide, right?
Yes.
But obviously it wasn't enough for you to make the determination suicide in this case, true?
True.
Would you agree with me that when you're specifically looking at manner of death, it's important for you to know facts about the death scene, for example?
Absolutely.
And facts about if there's a caregiver involved, that person.
Sure.
And if there's a law enforcement investigation, to understand that investigation.
Yes.
In this case, are you aware that Dr. Bedritsky felt the scene at Lynn Hernan's residence was staged?
I heard that.
Are you aware that she testified she had never seen the pill disbursement in this case the way that it presented, given the toxicology levels of Ms. Hernan?
I'm not sure I understand what you mean.
Would you agree with Dr. Bedritsky that if you came to a death scene and there were pills all over and pill fragments on the decedent and spoons and crushed pills on plates, and then you looked in the toxicology and there were no fatal levels of any of the prescription medications, that those two things seem to be in conflict with one another?
I guess I don't see the conflict. I mean, the scene that you've just described is sort of a chaotic, a person wouldn't know how much of any medication they're taking. And if they had a whole lot of, I mean, a few of a whole lot of different medications, it could look like more, especially if it's ground up, than it ended up being. So I guess I don't see the discrepancy there.
So if someone presents post-mortem with therapeutic levels of prescriptions that they've been prescribed before, yet at the scene there's powders everywhere and pills everywhere and there's powder on the decedent and on their chest with the spoon, that to you is not an inconsistent scene versus reality in the toxicology?
Well, I think she also had medication that she wasn't currently being prescribed. So that, again, as I've mentioned, raises some questions. Again, we don't know what it looked like 3 days before or a week before, or, I mean, I don't anyway. Maybe she often ground her pills and I don't know.
But it's also possible that someone dosed the victim with tetrahydrozoline, and while the victim is in a sedated state, gave the victim pills to take, and once the victim was deceased, crushed up medications and put them over the victim. That's possible, right?
Sure, that's possible.
And there would be no way to know because the only other person that would know the answer to the question is deceased.
Right.
Were you aware that in this case, this jury has heard evidence that at the time that Lynn Hernan died, she was only worth about $100?
I did not know that.
Okay. Were you aware that in the year to 2 years before Lynn Hernan died, the defendant seated to my right received $140,000 from Lynn Hernan?
I was aware she'd received some money, but I didn't know. I don't remember that I knew the exact amount.
Were you aware that leading up to Ms. Hernan's death, all of her credit cards were maxed out?
I'm going to object. That's not the testimony.
Yes, it is.
Overruled.
No, I wasn't aware of that.
Were you aware that after the death, this jury has heard evidence that the defendant profited about $87,000 from Ms. Hernan's estate account?
No.
Were you aware that that profit was to the detriment of another beneficiary on Lynn Hernan's will?
No.
Are those circumstances suspicious to you?
Sure.
Were you able to look at the 12 plus hours of interviews between Ms. Kurczewski and law enforcement in this case?
I reviewed some of them, but I did not listen to all 12 hours.
Okay. One moment. Those are all the questions I have. Thank you, doctor.
Thank you.
Redirect.
Thank you. I'd like to have my screen, document on the screen, please. Doctor, I'm going to show you what's already been introduced as Exhibit 541, which are Ms. Hernan's medical records from ProHealth. You were just asked about that, right?
Yes.
And I'll show you another page of the palliative records and page 591 of the exhibit. Do you see that in front of you?
Yes.
Does it talk about the physician's concern about whether Lynn is truly grasping her current medical condition?
Yes.
That they talked to her about her CT findings and that they need a colonoscopy, right?
Right.
And her chronic symptoms they thought could be related to colitis.
Right.
And she absolutely refuses.
Right.
You were asked questions about in your practice as a forensic pathologist if you consult with toxicologists.
Yes.
And in fact, in this case, isn't it true that that we have a toxicologist working on the team, Henry Spiller?
Yes.
And you've read his report?
Yes.
And you're familiar with his opinions on toxicology here?
Yes.
And you've considered those opinions informing your opinions in your report. It's one of the many things you considered.
Right. I reviewed his report. Yeah.
And one of the things that you consider from that information is how many pills are in a person. I think you talked about that. That goes to intent, doesn't it?
Right.
If a person has, you said 1 or 2 pills versus maybe 15 pills.
Right.
Or 20 or 30.
Right.
And do I understand what you mean by that is that if somebody has more pills in them that could go to an intent that they were trying to kill themselves.
Yes.
You agreed with the state that you and Dr. B agreed on some things. Is that
Yes.
right?
Oh, definitely.
She did not mention nifedipine in her report. Is that true?
Right.
And I'll bring up Exhibit 34. This is already in evidence, so this could be published.
Go ahead.
And she did not mention nifedipine. Is that right?
Right.
And we're looking at that under page 1, other significant conditions.
Right.
Are you aware that she didn't even realize that the pills that were undissolved in Lynn were nifedipine?
States the evidence.
Sustain as to the form of the question, please.
Are you aware that at the time she did the autopsy on Miss Hernan, she did not realize the nifedipine were the undissolved pills in Miss Hernan?
I guess I don't know when that decision was made.
You're not aware that the defense brought that to her attention?
I'm going to object to leading.
Overruled.
Were you aware of that?
I was not, or I had forgotten if I ever was.
The other thing on Dr. B's report on the autopsy protocol, which was amended on February 2nd, 2023, because she had missed a couple sections in her original report, right?
Right.
But her cause of death is she's concluded just the tetrahydrozoline poisoning, right?
Right.
And you don't agree with that?
No, I don't.
That can come down. Thank you. You were asked some questions about being consulted by people, other attorneys, whether they're prosecutors or defense. I think I heard you say that the majority of the time when you're asked to review a case, you agree with the medical examiner.
Right.
So the only reason somebody would hire you is if you have an opinion that, especially if it was a defense team, if you disagree with the medical examiner.
So often people hire me just because they want a second opinion. And as I say, most of the time I agree with the original pathologist, but the only time I would end up testifying generally would be if the attorneys that hired me thought I had something useful to add.
Right. So somebody like us, we hire you to review the case and you give us an opinion.
Right.
And if you agree with the medical examiner and we're defending somebody charged with homicide, we're probably not going to call you as a witness, right?
I get those quite often. Okay, thanks. Don't put anything in writing. Just send us your bill.
Okay.
Okay.
But you don't determine yourself that 95% of the deaths that you've autopsied or worked on are undetermined, do you?
No, of my own cases where I did the autopsy, I would say I was within the 5 to less than 10% range.
Just like what is recommended.
Right.
I want to ask you about the death scene.
Yeah.
Was there anything about the death scene that led you to believe it was staged?
No.
The ME thinks the scene was staged. You heard that.
Right.
How could a medical examiner know if a scene was staged?
Well, certainly I have seen photos or been to scenes that I was convinced was a staged scene, but it's generally been in a sexual assault context where the woman was positioned in such a way that she would not have occurred during death. That is, her legs were put in a certain position or her arms were put in a certain position that would not be the way someone's body would naturally end up after death because of gravity or the development of rigor mortis, things like that. So certainly there are cases that the medical examiner will go to a scene or see photos and feel like, oh yeah, this was staged. There's some sort of message we're being given or something like that.
Okay.
But most of the time, I would say when I've been to scenes, people's lives are more chaotic than they probably wish they were. And so it's hard to look at a scene and think, I mean, I can remember going to a scene and thinking, oh my gosh, the house has been ransacked. And the next of kin said, no, it always looks like that. So it's sort of, you don't know ahead of time what someone's life situation is.
The medical examiner seemed to think that the powder pills that were on Lynn's chest area, did you see that in the photos?
Yes.
That somehow suggests that somebody was standing up over Lynn and dropping things on her. That's really, in effect, what she testified to. If somebody does, and you've seen the picture, so did you see the orange dish that Lynn used to crush pills on?
Yes.
Did you see the little metal container and the spoon on the floor that she would use?
Yes.
And if somebody did crush their own medications to make it easy for themselves to take, does what you see on her seem inconsistent with that?
No, I think because of the way she sat in the chair, it was kind of a recliner chair. I mean, honestly, what it made me think of is when I eat a powdered donut and you end up with powder everywhere on your front, especially if you're kind of like she was in this reclined position. If she's trying to get something powdery in her mouth, I can imagine it would fall that way.
And when we carefully looked at the photos from the scene and compared them to photos later on at the medical examiner's office, well, Dr. B had not been to the scene. Her deputy was at the scene, right?
Right.
But she first saw the body was at the medical examiner's office. And she commented that she saw some particles of what she thought were pills, a few in her hair, in Lynn's hair. But when we look at the scene, we don't see that.
Right.
Dr. B testified that they're so very careful when they move a body from a scene to the medical examiner's office that there would be basically no disruption in what is on Lynn. Having told you that.
Objection that misstates evidence.
Sustained, please rephrase.
Medical examiner suggested that it's indicated that she trains her deputies extremely well, that they're taught to keep the body as still as possible and to bring it to the medical examiner's office as carefully as possible, to not disturb anything. Would that be fair that that should be done to the best of their ability?
Yes, sure.
How many autopsies have you performed in your career, would you say?
Oh gosh, over 5,000.
Okay, many.
Yes.
Have you been to scenes?
Oh yes.
So is it possible in a situation like Lynn Hernan to get her body from a chair and over to the medical examiner's office without disrupting anything?
No. I mean, you have to move the body from the chair to the body bag on the gurney and the gurney into the vehicle and then the body bag from the gurney at the medical examiner's office. So, I mean, things that are inside the body bag are going to move around a little, no matter how careful you are.
So as you've heard some testimony from, or some questioning by the state, Does anything that you were questioned about or any questions that you were asked today by the district attorney's office change your opinion on the cause and manner of death of Lynn Hernan?
No.
And so can you again tell the jury what your opinion is as to the cause and manner of death?
That the cause of death is mixed drug toxicity with all of the drugs that we've discussed, and the manner of death is undetermined.
I thank you.
All right, thank you, ma'am. You may step down. Thank you for being here. I presume she can be released from her subpoena?
Yes, Your Honor.
Any objection from the state?
No.
All right, thank you. It is 4:33, so that will be a good time for us to break for the day. Ladies and gentlemen of the jury, please do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the
I've rested quite a bit and sort of kind of liking it a little bit.